Chief Justice, I'm going to ask the Registrar Clerk to call the case with your leave.
Thank you. Please go ahead.
I am the Registrar Clerk for this hearing. Chief Justice and Justices of the Constitutional Court, all counsel are online. I call the matter of Jane Bwanya and Master of the High Court, Cape Town, and others for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
May it please the Court Justices, I appear together with Advocates Rabi and Tiat for the applicant.
Thank you, Mr. Stelzner.
Chief Justice, Justices of the Court, I appear on behalf of the third respondent in this matter, the Minister of Justice.
Thank you, Ms. Pillay.
Chief Justices, Justices of the Court, I appear on behalf of the first amicus, the Women's Legal Centre.
Thank you, Ms. Christian.
Chief Justice, Justices of the Court, I appear on behalf of the second amicus, together with Mr. Cohen, the Commission for Gender Equality.
Thank you, Ms. Adhikari. Mr. Stelzner, you've indicated that you'll need 10 minutes without interruption. Please go ahead.
I'm indebted, Chief Justice. Essentially, we seek to make 4 big points, and within that framework, we will provide details and thereafter answer the questions that the court undoubtedly has for the applicant. The first point is that although this case is that of the applicant, the issues that this case raises are of profound significance for a vast number of women, in particular, in the very same position or very similar position to that in which the applicant found herself. So it is a matter, we respectfully submit, of great constitutional importance and worthy, we respectfully submit, of the attention of this court for the 2 reasons which we've already motivated. Namely, firstly, there is a judgment of the High Court which declares the Interstate Succession Act, certain provisions of that act, unconstitutional and invalid, and that judgment requires the sanction of this court. And then there is also the other act which is implicated in this matter and which was assailed in the court below, but which the court below did not really deal with, and that's the Maintenance of Surviving Spouses Act. And in respect of that act, we apply for leave to appeal directly to this court so that both these issues can be heard simultaneously. And we say so for the reasons set out in our heads of argument, but basically that they're interconnected and that the arguments presented in respect of both pieces of legislation are in essence the same. The second point we make is that this case relies fundamentally on the provisions of Section 9 of the Constitution, the right to equality. And we respectfully submit that, and as this court has relatively recently also once again confirmed, that what is an issue is substantive equality, not formal equality. So although everyone may have the right to choose to get married or not to get married, and everyone has an equal right which they can or cannot exercise depending on the facts, what we respectfully submit is that Section 9 doesn't simply provide for formal equality, it provides for substantive equality. And that, we say, is why, with all due respect, until now, heterosexual life partners who did not comply with the formal requirements of the Marriage Act have, by and large, been excluded from the provisions of both the Interstate Succession Act and the Maintenance of Surviving Spouse Act. And that is because the formal requirement has been elevated above what Section 9 requires as substantive equality. And substantive equality one finds from Section 9 itself. It doesn't only say in Section 9(1) that everyone has the right to protection, equal protection. It also says everyone has the right to equal benefits under the law. And elsewhere in Section 9, we also find provisions similar. So this case is about benefits which are not extended to a survivor of a heterosexual life partnership. Whereas if the survivor had been of the same sex, that survivor would have obtained the benefits under the Interstate Succession Act, under the decision of this Honorable Court in Loubser versus Duplan, notwithstanding the fact that as at that date, same-sex partners could have chosen to conclude a civil union under the Civil Union Act, yet for a variety of reasons, which were apparent in that case, decided not to, or as that case decided, were unable to. So this has created, we respectfully submit, firstly, a differentiation between same-sex life partners and heterosexual life partners who have claims under the Interstate Succession Act. Both can get married or conclude a civil union, but in the one case, the one partner or survivor is allowed to inherit under the Interstate Succession Act. In the other case, she cannot. And the only reason for that, the only difference between the two, is that in the second case, she's heterosexual, a survivor of a heterosexual life partnership. And that is a prohibited ground for differentiation, discrimination under Section 9(3), sex, gender, sexual orientation. So as far as the Interstate Succession Act is concerned, we respectfully submit that the High Court, given the precedent which had been set by this Honorable Court in Loubser versus Duplan, was entirely correct in ensuring that the applicant had the same benefits that Mr. Loubser received from this Honorable Court under the Interstate Succession Act. So that is, I think, our third point about the Interstate Succession Act. The situation with the claim under the Maintenance of Surviving Spouse Act was, with all due respect, made difficult for the court below to come to the applicant's assistance on exactly the same basis as the court came to the applicant's assistance but under the Interstate Succession Act. And that was because of the judgment of this Honorable Court in Folks N.O. versus Robinson, a judgment which goes back to 2005, a judgment which provided that the legislature needs to address the various anomalies and needs and requirements that heterosexual life partners have and are faced with when it comes to benefits under the Maintenance of Surviving Spouse Act. The legislature for the last 15 years has not dealt with that issue. There was a draft bill, which was produced after the South African Law Reform Commission produced its first report, but that was never presented to Parliament for its consideration. We now, very recently, in this past month, have another report from the South African Law Reform Commission, which once again deals with the position of heterosexual life partnerships and members of that, what's called a protected relationship, and provides that they are entitled to substantively the same benefits, equal substantive benefits to other people in similar life partnerships, even without concluding any formalities, without getting married, without concluding a civil union. So the legislation has been produced. But the courts are, unfortunately, with all due respect, required once again to come to the assistance of an applicant, such as the present applicant, because that legislation is not there to assist them. And the applicant applied to court under the Constitution to have the legislation, which ultimately one anticipates will be amended, declared unconstitutional. And to that extent, this honorable court is required, we respectfully submit, to deal with the issue and to give the legislature also the necessary guidance in this regard. And then the second last point, by way of introduction, that we wish to make is that it's a life partnership, which is the essence of the matter here. It's to be distinguished from the rights of cohabitees. It's to be distinguished from relationships which do not have the same degree of permanency. It's to be distinguished from relationships which are not akin to marriage. And there are very different definitions which have been produced over the years, also by the courts, to describe the kind of relationship, the kind of life partnership, which we respectfully submit requires the protection that the applicant obtained in part, and this case now also seeks in full. And the difference there is that there must be a reciprocal duty of support, or as the South African Law Reform Commission in its latest report also defines it, which is part of the supplementary practice note, which we provided to this honorable court. And we quoted in paragraph 8.2 of that supplementary practice note, the definition which is proposed for a protected relationship: any life partnership where the parties cohabit and have assumed permanent responsibility for supporting each other. It's very similar to the wording that the court quo used in reading in, adding to the Interstate Succession Act in order to make that act constitutionally valid, to ensure that there are equal benefits for the applicant, as they would have been had the deceased died 3 months later. And although originally we also submitted that the applicant's position was so closely akin to marriage that they had in fact decided to get married and that they were engaged to get married. And we were prepared to also add that requirement for this life partnership to be treated the same as any formal marriage. But the court did not require that, and that was based on the judgment of the Supreme Court of Appeal in Pashao, which said that that was an arbitrary additional requirement which does not relate to the essence of the relationship here. Once again, a substantive equality approach as opposed to a rigidly formal equality approach. And the difference then between a cohabitee who under the common law is not obliged to support the person he or she cohabits with and vice versa, and a life partner, as we have in this case, is that there is a duty to support. And that duty to support, we respectfully submit, does not need to be one which arises from the conclusion of formalities. It's not something which is only available to someone if the law provides for it. It can also arise ex contractu. It can come about through conduct. It can be a tacit agreement. And if those requirements are met, then the only difference between a life partner who has a mutual duty and right of support and someone who has concluded a formal marriage is the fact that in the latter case, that life partner who concludes the marriage and would have been under the same contractual duties potentially before if they cohabited and had all the other requirements for such a claim. and will continue to be under those duties after they got married, except in addition, there'll be the ex lege rights. So, and the last point, which I'll deal with at the end, is remedy.
Before you get to the last point, the 10 minutes is long expired.
Yes, thank you, Chief Justice.
Thank you. You may continue though.
We will also
would put questions to you.
As the court pleases. We would also, at the end, make certain concessions as far as the remedy that we are seeking, and also in this draft order that we've presented to this court, which is based on the notice of motion. There is a mistake there, which the second amicus has pointed out. Although the order we presented is largely based on the judgment of this honorable court in Behe, and then the minority judgment in Folks versus Robinson, the mistake is that we talk about 3 definitions in the Maintenance of Surviving Spouse Act. There's in fact only one definition in the Maintenance of Surviving Spouse Act. That's the definition of survivor. The other 2 terms which we refer to there, marriage and spouse, they're not specifically defined in section 1 of the Maintenance of Surviving Spouse Act. They are terms which can be traced back to the judicial definitions which were adopted in cases in the past. So it needs that qualification if the court is with us as far as the Maintenance of Surviving Spouse Act relief is concerned. Namely, it's not that the 3 definitions need to be declared unconstitutional, but the one definition and the 2 terms which are referred to there need to be declared unconstitutional insofar as they omit to provide the same substantive benefits to life partners in life partnerships, and the requirement for a life partnership, which is also spelled out in the relief that we are seeking, is that they have mutual duties of support. If they have mutual duties of support ex contractu and the one dies, we respectfully submit, in order to ensure equality under the Maintenance of Surviving Spouse Act, in order to ensure equality also under the Interstate Succession Act, they need to be treated the same as someone in an Islamic marriage, as someone in a Hindu marriage, as someone in a same-sex relationship, because the courts have incrementally in all those cases extended those same benefits, although mainly under the Interstate Succession Act, but in a number of cases also under the Maintenance of Surviving Spouse Act, to parties who have not entered into a Christian formal marriage before a priest who is a marriage officer. If it's a marriage under Hindu law, or under Islamic law, or a religious marriage in terms of Hinduism or Islamic religion, the courts recognize that they're as much a spouse as anyone else. That's the court pleases.
Mr. Stewart, is the reference to those types of marriages, Muslim, Hindu, apt? I ask because those are marriages. It is just that they were not recognized, but they are marriages.
Yes.
For argument, do you think reliance on cases like Ahmad and whatever other case is apt?
I accept, Justice Matlanga, that the position there is different to an extent to that of life partners, but there are very many similarities. The point I'm making is that there the court has not insisted on strict compliance with the formal requirements of the Marriage Act. And the court has done so by interpreting the word spouse to mean, yes, anyone who is married in whatever, according to whichever religious religion or whatever other procedures there may be, for that to be a recognized marriage. And I think reliance is also placed on section 15 of the Constitution, which specifically provides for such marriages to have equal validity. So indeed, my lord, sorry, Justice, the difference is that in this case, the parties did not formally conclude the marriage, but they came very close to that. It was just the question of Lobolo, which needed to be negotiated. And once that had been negotiated, and the requirement was that it be done in person, so they had to go to Zimbabwe. Once they'd come back, the evidence is that they would have got married. So, and then also one has the incremental provisions in BER and other cases in respect of customary marriages. So those marriages, indeed, I accept the point that those were marriages under those religions and traditional systems. The court recognized those by not insisting on the formal requirements of the Marriage Act. Now, we're similarly asking that in a life partnership such as this one, and the others which satisfy that test of equal duties, reciprocal duties of support, whether financial, whether in any other fashion, we respectfully submit, require the same approach, the same consistency to elevate a formal marriage requirement under the Marriage Act to be the exclusionary reason that someone such as the applicant is deprived of the benefits that she would otherwise have had under these two acts, is to
may I find out this? Although, of course, I doubt that it would be proper for us to go back on what was held on the facts, which is that a permanent life partnership existed. That's a factual finding that has been made, and our judgment says we do not upset such factual findings. But I'm quite interested to find out how, in a situation where the facts demonstrate that the parties never intended that theirs be a permanent life relationship outside of a marriage, and that their intention was actually that they be married in, let me loosely say, in the conventional sense, how then the stage before that final step can also be referred to as a permanent life relationship.
Yes.
I know, of course, that may be quite schizophrenic to reason that somebody like that who actually wants to eventually get married must be disadvantaged to one that never intends to get married and is in a permanent life relationship. But there's somewhat of a contradiction in terms.
Yes, as you pointed out at the outset with respect, it's a factual question. In Pashao versus the RVFF, the Advocate Chaskelson for the RVF presented the same difficulty to the Supreme Court of Appeal, to say that, well, the Road Accident Fund is not going to be able to establish whether this is a life partnership with reciprocal duties of support, a permanent relationship akin to a marriage, or whether it's a cohabitation where there's no permanency and there's no contractual agreement of parties supporting each other. And the SCA said, but that's not a reason to come to the assistance of the applicant in that matter, or the plaintiff in that matter, who had established that she fell into the former category. It's a factual question, and people will have to decide and determine those on the facts. But the requirements, the legal requirements for recognition, we respectfully submit are clear, and it's a permanence. It's that it's going to be for the foreseeable future. In fact, the definition of marriage is also not forever. It's until it is dissolved. But the requirement for a life partnership, in order to make it akin to marriage, we would respectfully submit that the closer you are to marriage, the more the parties have agreed that they will get married, and the fewer reasons there are for their not getting formally married, well, the more likely they will be able to prove the facts that need to be proven in order for them to claim the same relief as those who did formalize their relationship. So we don't, and as the court pleases.
I didn't mean to interrupt you. If you're
Not
still
at all.
answering my brother's question, please continue.
It may be a separate point, and it's the point that the first amicus also makes right at the outset, is that this is not a threat to the institution of marriage. We're not seeking to undermine the importance of marriage. We're simply seeking to make sure that those individuals who are in a relationship very similar to marriage are not deprived of benefits that they need, which also brings one to the substantive equality requirement. But that's another point. The real need for a large number of vulnerable women in relationships which have not yet been formalized. Sorry, Justice Strong, I slipped in an extra point there.
Mr. Southner, excuse me, you referred to couples who had the desire to get married. I had understood the applicant's position in the High Court to be, in respect of the maintenance challenge, that the reading in should include, and I quote, this is what I understood the applicants to have been seeking in the High Court, the surviving partner in a permanent opposite-sex life partnership in which the parties had undertaken reciprocal duties of support and had been committed to marrying each other.
Yes.
Has that position changed? Is the applicant now requesting a reading in, that the reading in should extend to all permanent life partnerships?
There are two aspects there, Justice Strong. The other point is the one that the amici will also be making, and that is to include the opposite sex provision, which is not specific to the applicant's situation, may then create further problems once again, as far as same-sex life partners are concerned. And the solution there is simply to call it life partners, whether they're opposite sex or same sex. So we are not insistent on it being restricted to opposite sex partners. We say the principle must apply to all life partners, whatever gender and whatever sexual orientation. So to that extent, we are not insisting, and if required, we abandon that qualification. And in the court below, on the precedent of Pashar versus the RVAF, we also did not insist and abandoned the further requirement, namely that the parties needed to intend to get married. What we argued, and we still argue, is that that is a further fact which points to the permanence of the life partnership. Maybe one of the fucked up probantia, but it is not a requirement we respectfully submit in order to achieve equality. So it may be one of the facts that Justice Matlanga touched on, that one would have to bolster one's case, as the applicant has in this case. But we agree, with all due respect, we're following the precedent in the SCA, that to impose that intention as a strict requirement is moving once again too close to introducing too many formal requirements, when the essence of the matter is the duty to support. And then that then relates to the purpose of the legislation and the benefit that a vulnerable surviving spouse desperately needs, as these facts also show. On these facts, if the court did not come to the assistance of the applicant to the extent that, well, there's the settlement, which is another point, but the settlement is premised on her being entitled to a share of the Interstate Succession Act. And this is why we're before this court, to have that decision of the High Court confirmed. If the court did not come to her assistance and did not declare the Interstate Succession Act unconstitutional, well, then the estate would have devolved on cousins in Hawaii and Australia and elsewhere. And the applicant, who's the one who the deceased would quite clearly on the facts also have wanted to benefit from the estate so that she could be supported, is left high and dry, simply because he died a few months before they could get married. And we're
Mr. Stelsner, once you're done, I'd like to ask you something following on that, please.
as the court pleases, Justice Majid.
Are you done?
I am.
Yes, it's related, and this involves the Maintenance of Surviving Spouses Act, and particularly what concerns me is the point that the High Court raised in Stare Decisis and Vox versus Robinson. What must we do with that case as far as the maintenance claim is concerned? Must it be distinguished on the basis of the facts of this case, because it's uncontroverted on the evidence that Ms. Bwanya and her partner were going to get married once the Lobola negotiations had been concluded. But unfortunately, his unfortunate passing subverted that intention. Now, do we distinguish Vox versus Robinson based on that intention? Because the majority decision in Vox versus Robinson says, where you have a choice to get married, you're not entitled to that same benefit. That was then. And then the other alternative is to revisit that judgment in line with the minority judgment in Loubser versus the minority concurrence in Loubser versus Duplan, where Justice Vroneman expressed his disquiet with that decision. What must we do with Vox versus Robinson?
As the court pleases, that is the other crux of the matter, which is why we before this court, and also why we're seeking leave to approach this court directly in respect of the Maintenance of Surviving Spouse Act provision, because if we had gone to, for example, the full bench and from there to the SEA, on each occasion there, the stare decisis point, which you make, would have been the end of the matter, basically, and we would have had to then come to this court for this judgment to be considered. And this court is now free, we respectfully submit, also on the basis of stare decisis and without undermining the rule of law, to reconsider this specific application, either on its own facts and distinguish these facts from those in Folks versus Robinson, which I will address in a moment, or alternatively, as your lordship, as you point out, Justice Majid, the approach, the more principled approach with respect of Justice Vroneman in a concurring judgment. It's not really a minority judgment, it's a concurring judgment in Loubser versus Duplan, where the majority says these arguments are compelling, and where the majority also finds that there will be a time, or there may be a time, when folks needs to be reconsidered. But that case was not the time, because the evidence which the court considered may still be necessary to decide the position of heterosexual life partners properly was not before the court, and in fact it hadn't been pleaded as such a case. So that the case which is now before this court is the case which the court in Loubser versus Duplan said may one day present itself and will then need to be considered fully. So we accept, and we argued that in the court below, that there are important factual differences, and those factual differences also to an extent impact on the principled decision. So one of the factual differences is that there was a will, that in that case, the deceased, Mr. Shandling, had a will and left 1/3 of his estate to Mrs. Robinson. And Mrs. Robinson then was claiming maintenance in addition to that which she was going to inherit. And it was in those circumstances that the court said, but we can't come to Mrs. Robinson's assistance here because that would be to interfere with the wishes of the deceased. And that's really, apart from a choice of marriage argument, a freedom of testation argument, and the courts respecting the wishes of the deceased who had provided in a will effectively for maintenance, and to recognize the Maintenance of Surviving Spouses Act in those circumstances would have been to deprive the heirs, the residual heirs, of the 2/3 of the estate, which the deceased had specifically provided in his will needed to go to them. So that is a crucial difference, because what we have here is an interstate succession position, and the requirement under the Interstate Succession Act is to provide for someone such as the applicant, where there is not a will, where the deceased did not make the necessary provisions. And there's a debate about whether the Interstate Succession Act also deals with support or not, but we respectfully submit that on these facts, by depriving the applicant of what would be the whole estate, because she's the only interstate heir under the Interstate Succession Act, because there are no children, there are no parents, there are no brothers, she would under that act get the full estate. And therefore, it's a crucial difference. The fact that there was a will in folks, there's no will here. Interstate Succession Act applies, which in turn impacts on the Maintenance of Surviving Spouse Act. There's no problem with her inheriting anything.
Mr. Stelzner, I realize, of course, that my brother, Justice Majid, is probably not done yet, but I think I should come in the middle of your argument in this regard. I have difficulty understanding a submission, the subtext of which is that a statute may be unconstitutional in respect of some who fall, some life partnerships because of these facts, and may be constitutional in respect of other life partnerships who fall under a different set of facts. I have a fundamental difficulty with that. I would have thought it's either that all opposite sex life partnerships should be included, or they should all not be included. I just, at a principled level, do not quite get the point of a factual distinction. I have fundamental difficulties with that.
As the court pleases. And Justice Matlanga, that's exactly then the point that Justice Froneman made in his his concurring decision in Loubser versus Duplan. It says that to distinguish the two cases on the facts doesn't address the two principled issues. And the two principled issues are that the majority in Folks versus Robinson had a marriage-centric approach and attached, we would submit, too much importance to the question of choice and freedom of choice. As for the second point, the minority and Justices Mokgoro and Regan in Folks versus Robinson, they make the point that this wasn't a joint decision not to get married. Mr. Shandling may not have wanted to get married and may have told his friends that he didn't want to get married. But Mrs. Robinson, there was no evidence that Mrs. Robinson didn't want to get married. So it illustrates the point, and that's one of the reasons that the minority in Folks versus Robinson found for Mrs. Robinson that there's not an equal choice. And the situation often, and as the evidence before this court shows, in millions of cases, are such that as much as people would want to get married, or as much as one party wants to get married, there's no real freedom of choice. People often don't get married because they have no choice, but they are in life partnerships with duties of support. So we respectfully submit on a principled level, the choice argument can and should be revisited. To get back to the stare decisis point, it can be revisited by this honourable court in the Camps Bay ratepayers decision, and the preceding decisions make the point that if this court is of the view that Folks versus Robinson was wrong, it can depart from it. If it comes to the view that Folks versus Robinson was decided on its own facts, in its own time, without all the evidence that the court now has before it, and this was 15 years ago, nearly 16 years ago, and the evidence that the court now has, and the Law Reform Commission reports and everything else that the court has before it, the statistics, the anecdotes, the case studies, that if the court now concludes that Folks versus Robinson was incorrect, then the court can do so.
Mr. Stelzner, I want to ask you a direct question, but before that, my brother Justice Majid, were you done?
Thank you. I actually have the same problem that you raise, and that is how something on this set of facts is constitutional, that statute, but not on a different set of facts. So please continue, my brother. That's exactly the line I was pursuing, because it just seems to me on the face of it, Mr. Stelzner, that distinguishing on the facts and on the choice basis really doesn't seem technically sound for the reasons that my brothers also advanced. So please continue, Justice Madlanga.
As the court pleases, if I may just add, it also doesn't address the substantive inequality. Those two arguments are formal arguments. They're more formalistic, and they don't address the real issue which has now presented itself, and that is that a vulnerable group is deprived of benefits which they would otherwise be entitled to had they complied with the formal requirements. Had they chosen to get married, to use the words of Folks versus Robinson, had they concluded the marriage around which the majority based its whole decision at the time. And yes, we respectfully submit that the approach of Justice Vroneman, the more principled approach, is one that this court, with all due respect, should adopt, because the facts before the court now show that that is what equality, Section 9(1), Section 9(2), Section 9(3) of the Constitution demands, with all due respect.
I said I wanted to ask you a direct question. So you said there are two options. It's either that Folks v. Robinson was wrong, or that we may adopt an approach that says there has since been a change. The direct question is, are you saying, especially regard being head to the last thing you said about Justice Vroneman's approach, are you saying Folks v. Robinson was wrongly decided?
Sorry. I would, with all due respect, be very presumptuous, Justice Madlanga, to make that submission. And although the academics, which Justice Vroneman also refers to in the Loubser versus Duplan case, in extensive arguments, have pointed out, with all due respect, all the principled and constitutional flaws in Folks versus Robinson. Our approach would be slightly more differential, and we respectfully submit that that is the approach which the stare decisis principle requires. The Camps Bay ratepayers judgment, the Turnbull Jackson versus Hibiscus Coast municipality judgments make the point that even a court below can respectfully disagree with the Constitutional Court's judgment, and the Constitutional Court judgment, the Constitutional Court itself then can also, with all due deference to the judges who decided the matter then in that context, say that now in this context, it needs to be decided differently. And that is our submission, that without saying that Folks versus Robinson was wrong, the Constitutional Court was wrong, and that the High Court in the preceding matter was correct, and without saying, well, if I as a Constitutional Court judge has sat in the matter now I would have decided it differently. We simply saying that these facts, all the evidence before the court, cry out with all due respect for a remedy which is different to the one that the court decided was the appropriate remedy in Folks versus Robinson. So if it's necessary to say that Folks versus Robinson was wrong, we respectfully say that applied to these facts, we are arguing that the Constitutional Court would not have come to the same conclusion that it did in Folks versus Robinson. Also on the principled points that we've already raised and addressed. As the court.
Mr. Stelzner, one of the reasons why the majority in Folks versus Robinson declined to declare Section 1 of the Maintenance Act unconstitutional was the view that the regulation of life partnerships would best be handled by Parliament. And that brings us to the separation of powers issues. And Folks versus Robertson deals with that at paragraph 67 and 68 of the judgment. And they recognize that, yes, there are vulnerable women who would be unfairly discriminated against if that section 2.1 was not extended. But they say the answer lies in Parliament enacting legal provisions that will assist them. Now, while the facts might be different, is that still not a relevant concern?
Had Parliament adopted the Domestic Partnership Bill, which was prepared after the South African Law Reform Commission, of which Justice Mokgoro formed part, produced its report, then the applicant and everyone else in similar positions would not have been before this court, would not have asked this court to decide the matter. The only reason we're here is because Parliament has not done that which this court required it to do 15 years ago. And we respectfully submit that as far as the remedy is concerned, the applicant is now before the court. The applicant does, and people in her position require the vulnerability, which this court identified 15 years ago already, to unfortunately be addressed by this court because Parliament has not done what Parliament was required to do.
That is a competency that falls within the domain of Parliament. If Parliament has decided for whatever reason not to change or introduce new legal provisions, would this court not be stepping or overstepping its mark in doing what it feels that Parliament should do?
Yes, and our argument is based on Section 172, the powers of this court, and also that which we respectfully submit the Constitution enjoins this court to do in circumstances such as these, and that is, and it uses the word must in Section 172.1. When deciding a constitutional matter within its power, a court must declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency. Now, the fact of the matter is that Parliament has simply omitted to deal with it. It's not as if Parliament has passed an act in terms of which they say life partners are not entitled, or more specifically, heterosexual life partners are not entitled to any benefits. If that were the case, well, there'll be another constitutional challenge before the court. Parliament has simply omitted to do that which the court required it to do 15 years ago. There's a gap, and that gap, we respectfully submit, under Section 172.1 must be filled by the courts, including this court. Otherwise, the applicant and all those in her position will have to wait who knows how long for Parliament to get round to discussing and adopting that which the South African Law Reform Commission twice already has spent so much time producing. And what we respectfully also submit is that the fruit of their labors will inform this court too, because the definition, which we touched on right at the beginning, of protected relationships, which is close to life partner, the protection that the proposed act legislation provides for, the amendments to the Interstate Succession Act and the Maintenance of Surviving Spouse Act, in those recommendations of the Law Reform Commission, they all point to the fact that there is this need. And we respectfully submit that if this court decides this matter or confirms the decision of the High Court based on the Constitution, it is not entering into the arena of legislating. It's exercising its powers under Section 172(1), which the Section 172(1) of the Constitution enjoins it to do in cases. So for 15 years, sorry, with all due respect.
Sorry, just a point of information on the bill. I know the Law Reform Commission's report was 2006, and the bill was promulgated in which year? Was that in 2007?
I think 2008, Justice Majid, we have as schedule, as one of the schedules, I think Schedule 1, to
Yes.
our heads of argument, a chronology of not only the various cases and the incremental changes over the years, but also included in that is the legislation. And in that schedule, item 29, Your Lordship, so the court will see, January 2008, the draft domestic partnership bill was published. And if one goes up along that list to number 20, one sees in February 2005, Folks versus Robinson was decided by this honorable court. In March 2006, so roughly a year thereafter, that's item 22, the South African Law Reform Commission report on domestic partnerships was produced. So the SALRC conducted the necessary surveys, interviews, workshops, did all the international research within a year.
I've got that. Sorry, I've got that date now. It's 2008. What I want to check with you, we should really ask the minister this, but what has happened since 2008? Has the bill gone through the committees? Have public participation been invited? Do you know anything about that?
All we have in the same schedule, Justice Majid, is number 31. There was a statement, I think I got that from LAWSA, on marriage, volume 27 or 28, I think. In June 2008, there was a statement by the Department of Home Affairs that domestic partnership legislation would be finalized within the next 2 to 3 years. And then item 33, one of the pieces of legislation which was indeed passed in response to the judgment of this court in Be, was to then deal with the reform of customary law and succession and the male primogenitor provision, etc. So there was some legislative response. And then what is not part of this list, but that could be item 42, is that which we've identified in our supplementary practice note. Around about the 21st of January of this year, there's been a further South African Law Reform Commission report, and they've stated that I think March of this year is a closing date for further submissions. We respectfully submit that this case, firstly, the applicant is in need of confirmation of the judgment so that the master, the executor, everyone can deal with the matter in accordance with the law as confirmed by this court. But other individuals are in similar positions and they cannot wait. And we respectfully submit in the circumstances, they're not required to wait for the legislature to deal with it. When the legislature has not dealt with it, but when one has these reports from the Law Reform Commission, which are extensive, not only 500-600 pages, but the research and the submissions are meticulous, with all due respect. And they all point to that which the court quo decided as far as Interstate Succession Act is concerned, and what we are arguing for in both matters now. So to put it crudely, the legislature needs, if I may submit, guidance and reconfirmation 15 years later that it not only must deal with the matter, but also how it must deal with the matter.
Mr. Stasna. Mr. Stasna?
Yes, Justice Jafta, I can hear you.
Okay. Can I clear a few things with you? Insofar as the substantive equality argument is concerned, between the life partnership situation and the marriage situation, how far does that argument go? Does it suggest that all rights and duties arising from marriage should be extended to life partnerships? Or does it say some and not all should be extended? I just want to understand that.
And that, I must concede, is something that the legislature is going to deal with, and the Law Reform Commission, with its proposed legislation, has also dealt with. And also the Civil Union Act, to a large extent, has also equated civil unions, which then comply with those formalities, to marriages and provide for all the benefits other than in the Marriage Act. And we respectfully submit that, yeah, that equalization is occurring, has occurred, and how far that will go will ultimately be determined by the legislation. But in this case, the fundamental aspect which we present to the court is the fact that there was the reciprocal duty of support, which the applicant now no longer has by virtue of the death of her life partner. And the claim essentially is limited then to those provisions under the Interstate Succession Act and the Maintenance of Surviving Spouse Act, which deprive her of the relief that she would have otherwise received. And we take it no further than that, Justice Jafta. This case doesn't ask this court to go any further. And we concede that there are all kinds of other issues which will present themselves in due course in other matters. But this court has, and that also returns to Justice Cron's separation of powers point, dealt with these matters, with all due respect, incrementally, based on the facts before them, and to the extent required by that specific case. So we're not asking the court to decide any other potential possibilities.
So you agree that ideally it is the terrain of Parliament to deal with these issues, because it seems to me, as a matter of principle, substantive equality would not be satisfied or met even in respect of other rights and obligations. But you are saying you don't want to go beyond what has been raised in these proceedings. Is that the argument?
Those are our submissions, Justice Jafta, and we respectfully submit that the court cannot go beyond that without entering into the realm of legislating. So what you're asking the court is to decide the constitutionality of this legislation on these facts. But what the court also has from the amici is the fact that it's a widespread difficulty experienced by many vulnerable women. And in Folks versus Robinson, the court recognized that, as Justice Strong, with all due respect, alerted me to. But in the absence of legislative intervention, the applicant has no option but to apply to court for the relief that she applied. Had she not, well, the facts are there.
I must immediately point out that I have no problem. I think the High Court was correct in declaring the Interstate Succession Act invalid. I have no problem with confirming that order. My area of concern arises in respect of the appeal issue on the Maintenance of Surviving Spouses Act. And I just want to find out the reason why you're saying because Parliament has not done what it was supposed to do, this court should come in is because the argument, as I understand it, is that those who would otherwise benefit from the statutory right under the Act are left without remedy, or am I mistaken?
Indeed, Justice Jafta, with respect, there's also the issue about whether the relief that the applicant is seeking in its entirety is moot or not, and whether the court needs to go further than simply dealing with the applicant's case. The amici will address the court, I'm sure, on the fact that the issues which are at stake here are of more general relevance and importance than simply applies to the applicant. And your lordship, sorry, the court also on these facts could say, well, given the decision of the High Court under the Interstate Succession Act, given the facts which present themselves with the applicant having been the sole heir entitled to the whole estate, the maintenance of surviving spouse relief doesn't really enter into it. But the way the legislation works in practice, I understand, is that one first has a claim under the Maintenance of Surviving Spouse Act, and then in determining whether the estate should settle that claim, well, one of the issues which the executor under the Administration of the Estates Act must take into account, subject to the control of the master, is whether the spouse or the survivor is also inheriting. And if the spouse is inheriting quite a substantial amount, well, then she doesn't have a claim under the Maintenance of Surviving Spouse Act because she can provide for her own needs out of the inheritance. So there is this interplay, and notionally and logically, the Maintenance of Surviving Spouse Act should be the first port of call. And that is the fundamental issue which one would argue needs to be treated in exactly the same manner in which the Interstate Succession Act provisions are treated. So the both issues are before the court because we respectfully submit that the same arguments, the same constitutional arguments apply in both cases, and one cannot deal with the one without dealing with the other. And as also pointed out in Loubser versus Duplan by His Lordship Justice Fruneman, that even though that case was an Interstate Succession Act case, and even though the claim there was an Interstate Succession Act claim, it does raise the very same principled issues that were decided in Folks versus Robinson. And one cannot avoid dealing with a Maintenance of Surviving Spouse Act claim and how Folks versus Robinson dealt with that claim without being inconsistent as far as the Interstate Succession Act claim is concerned. And those are the anomalies which have now presented themselves. Under the Interstate Succession Act, same-sex life partners can inherit, heterosexual life partners can't. Under the Maintenance of Surviving Spouse Act, it appears that there's no case that we are aware of in terms of which same-sex survivors or survivors of a same-sex life partnership can present a maintenance claim. That hasn't been dealt with. And similarly, as we know from Folks versus Robinson, the survivor of a heterosexual life partnership, as things stand at the moment, does not have a claim under the Maintenance of Surviving Spouse Act. So we respect that they're interrelated.
Am I wrong, and correct me if I am, to think that the Maintenance of Surviving Spouse Act does not create a right, a statutory right that was not there. It merely extends the application of a right that existed whilst both parties were alive. Am I wrong?
The one interesting thing is, just as a side issue, is that the Maintenance of Surviving Spouse Act was only introduced relatively late. So we respectfully submit, sorry, in 1990. So as I understand the legal position before 1990 is that by virtue of a marriage, the spouses were under a legal ex lege obligation to support each other. But on the death of one of the spouses, that obligation came to an end. So that is why the Maintenance of Surviving Spouse Act was introduced, in order specifically to protect a surviving spouse who is in need of maintenance post-death, and to then empower the executor to deal with that claim as a concurrent claim, together with claims of children for their maintenance, and to make provision for the maintenance as a first expense against the estate, in order for the spouse not to be left without maintenance simply because of the death. So my understanding is that the Maintenance of Surviving Spouse Act was introduced to deal with the lacuna which existed as a result of the common law duties of support of a husband in a marriage or a wife in a marriage coming to an end upon the death of one of those. The introduction or the preamble to the Act is to provide the surviving spouse in certain circumstances with a claim for maintenance against the estate of the deceased spouse, and to provide for incidental matters. My understanding was that a surviving spouse did not have an ex lege claim prior to this Act against the estate for maintenance, notwithstanding the fact that during the lifetime of the deceased would have been under an obligation to provide support, which is why we respectfully submit that the same kind of substantive protection and benefit which Section 9 requires be extended equally should also be extended to any other survivor who during the lifetime of the deceased had the benefit of the deceased's contractual duty to support her or him, and not to recognize that post-death as a claim against the estate, similar to that a surviving spouse now has since 1990, is in conflict with Section 9 of the Constitution. And then
so which means that we have to look back to the time when both parties were still alive and say, here was the right to be maintained with the corresponding obligation to maintain existing before one of the parties died. And the only thing that this Act does is to preserve that right and to make it exercisable after the death of one of the parties. Or am I wrong?
And unless the constitutional amendments to which we propose to ensure the validity of this Act, the Act as it now stands differentiates, and we respectfully submit unfairly discriminates against survivors simply on the ground that they didn't formalize their marriage.
Now, I understand that part of the argument. I'm trying to put my head around it, because what concerns me, which I would like to hear your views on, is during their lifetime, on the one hand, the life partnership parties have an ex contractu right of support. And the married parties have an ex lege right of support. And on your argument, can parties to a life partnership demand during their lifetime to enforce an ex lege right of support?
As the law stands at the moment, I understand it to be that they can enforce that right ex contractu, but ex lege, specifically as far as cohabitees are concerned, cohabitees don't have claims for support against their fellow cohabitee. The distinction, and that's the one we drew at the outset, and that's the one which is consistently drawn, is between people living in a relationship as cohabitees or those living as life partners. And one of the requirements for the life partnership is that there be this reciprocal mutual duty of support, a right of support. What the Law Reform Commission in its latest definition proposes is where parties cohabit and have assumed permanent responsibility for supporting each other. So the answer to your question, Justice Jafta, is that it's not necessary for an ex lege right of support to be able to claim support. One can have it ex contractu, but then there needs to be a contract based on the facts, conduct of the parties, their agreement that they would be supporting each other and be obliged to support each other and be obliged to continue supporting each other as long as they live or as long as their relationship continues and endures. And what we're now saying in terms of this legislation, which was there to provide for the benefit and the protection post-death, to then also be applied equally to those who are in the same position as someone who's married, except that they didn't formalize the relationship and therefore didn't have the ex lege claim, but had the ex contractu claim. And Pashao extends the common law on that very basis. Pashao, with the claim of a dependent for the loss of support as a result of the death of the breadwinner, acknowledges that the common law was that when the breadwinner dies, the survivor has no claim. And a life partnership, as was found to be there, notwithstanding the ex contractu rights of support during the lifetime. And what the SCA in Pashao did was to extend the common law to make it constitutional, to ensure that such a life partner has the same benefits as a spouse.
Yes, I think we're getting closer to the area that bothers me most. On the development of the common law under Pashao, the law now is, if I have an ex contractu right to be supported, I can enforce that right even after the person who was supporting me has died. Is that not the law now?
Indeed, my lord. And it's developed. It wasn't that before Pashao, it is that now.
So you don't need, strictly speaking, in respect of ex contractu right of support, you don't need the Maintenance of Surviving Spouse Act, because you can still enforce your common law right to maintenance, even though the person who was maintaining you has died.
In the case of unlawful death of the breadwinner against the person who caused the unlawful death. But in this case, it's a different claim with all due respect. It's a claim against the executor of the deceased's estate to deal with the claim as part of his or her administration of the deceased estate and pay, irrespective of the cause of death or who caused the death or who's liable for the breadwinner no longer being there to comply with his or her duty of support. So although there are similarities, the applicant's claim is not against a third party. It's a claim against the executor, and it needs to be dealt with under the Maintenance of Surviving Spouse Act. So although the same development and extension as occurred in Pashao, we respectfully submit should equally apply here. It's in a related but slightly different context, in that the claim's not against the RVF fund, the claim's against the executor of the deceased estate. But
as a matter of principle, does it make any difference?
No, Your Lord, I'm sorry to interrupt. I'm in agreement. We rely on Peshawar, and we're in agreement with the court, with all due respect, Justice Jafta, and that is that there needs to be a recognition of a post-death duty of support.
Yes.
As it was in Pashao, where what was originally ex contractu was then recognized by the court, who developed the common law, and now has become an ex lege right of the survivor. What we're arguing for in this case is very similar. That originally the requirement would have been that it was ex contractu, and after death, the court then recognizes it as being a statutory right by virtue of the Maintenance of Surviving Spouse Act, as read in order to make it constitutionally valid, and provide equally for someone who had an ex lege claim before against the spouse by virtue of the marriage, to someone who had an ex lege claim, sorry, an ex contractu claim previously by virtue of the terms of their life partnership.
Yes, I've taken much of your time, Mr. Stelzner. I'm sorry about that, but these are the issues that exercise my mind. My concern is this: would we not have unintended consequences if we were to declare the act invalid and say everybody in a life partnership is entitled to the statutory right as well? When, you know, in dealing with remedy, we read in certain words. We would be saying everybody in a life partnership is entitled to the statutory right. My concern is this: yet at the common law level, those people would still retain also a right emanating from contract, which places them in a position that is more advantageous than the position of married people, because those married people are limited only to the ex lege right, which is preserved by the Maintenance of the Surviving Spouse Act after death of one of them. Won't we say, in an effort of equalizing, end up with creating an unequal situation, depending on whether your right is sourced from marriage or your right is sourced from life partnership?
Our submission is that whatever claim a life partner who can establish that there was a duty of support during the life partnership presents to the executor would have to be treated in exactly the same manner as a claim of a surviving spouse, because the Maintenance of Surviving Spouse Act says you're only entitled to the maintenance you need, reasonable maintenance, and that depends on your means. And if you have sufficient means to provide for yourself, well, then you don't have a claim against the estate for additional maintenance. So to that extent, we respectfully submit the answer to be found is in the Maintenance of Surviving Spouse Act itself. A potential problem may possibly present itself if it's not a monogamous life partnership, but yeah, that is not the case before this court. And there are other cases, polygamous Muslim marriages, where a survivor of a polygamous marriage was entitled to a claim under the Maintenance of Surviving Spouse Act for her maintenance. We respectfully submit that those claims can all be dealt with in the same manner, and a life partner is not in any better position than a spouse, as currently defined in the Marriage Act or in legislation, who married in accordance with the Marriage Act. We don't think, with all due respect, that there is going to be more benefits for a life partner. Although in Folks, one had the argument, which we've already presented, that Mrs. Robinson would have been better off under the Maintenance of Surviving Spouse Act than she would have been under the will, but that was because there was a will. In this case, we're dealing with the interplay between interstate succession and maintenance. So I'm sorry, Justice Jafta, I cannot think of an example where a life partner is going to be in a better position than a spouse under the Maintenance of Surviving Spouse Act. That's the short answer. Eventually.
No, I understand. My concern was, if you give them a statutory right, you are giving them a right on top of a contractual right. Now, finally, would it be competent of this court to say, if they are to benefit from the statutory right, they should forego the contractual right? Can we do that?
No, I don't think the two coincide. So the position under the Maintenance of Surviving Spouse Act is to deal with the claim that a surviving spouse has by virtue of that act, and that's to make sure that there is maintenance for a surviving spouse, because ex lege, after the death of the spouse, there wasn't such a claim. So in that case, an ex lege claim during the marriage is now provided for in legislation post-marriage. What your lordships, what the courts and your ladyships, and sorry, justices are asked to do in this matter is to ensure the same equality, namely that life partners who have ex-contractu claims during their life partnership are treated the same way if one of them dies, in that they would also then similarly have a claim for support against the executor under the Maintenance of Surviving Spouse Act. So we don't respectfully submit that the contractual claim that a life partner would have had during the lifetime of the one partner continues beyond the lifetime. The same would apply as the ex lege claim previously. We would say that the Maintenance of Surviving Spouse Act was introduced to fill that gap where spouses die, and in order for equal protection, equal benefits to be afforded to life partners, we ask for the same equalization.
But I thought Pasha was dealing with that issue, that if you had an ex-contractu right of support before the death of the person who supported you, you can steal and force that right after the person has died, which is the ex contractu. So I had thought that if you take Pashao on the one hand and the Maintenance of the Surviving Spouse Act and put them together, you have one, a statutory right and a contractual right available both then, if we uphold your argument, available both to a life partnership surviving person, something that is not available to those who were married. That is what really concerned me, but I had your argument, your submissions on it. Thank you.
Justice Shafter, if I may just finish it off. The position in Peshawar was that after the death of the life partner, the obligation of the life partner to support the survivor came to an end, and there was no claim against a third party for compensation for the loss of the breadwinner. Now, the common law was extended to equalize the position of the life partner there with the position of a spouse, because a spouse had a claim for the loss of support, qua dependent and by virtue of the duty of the breadwinner to support her. So similarly, if a spouse loses the breadwinner as a result of unlawful act of a third party, that spouse, if it's in a motor vehicle accident, will still have a claim against the RVAF, but that spouse would also, in addition, have a claim under the Maintenance of Surviving Spouse Act. And the question then would be, what are her needs and what is she able to provide for herself? And if it transpires that she has received or will be receiving a substantial payment from the RVAF, well, then that would be taken into account in deciding what the maintenance entitlement under the Maintenance of Surviving Spouse Act is concerned. So we're simply saying that, well, the same that applies to a spouse under both these acts with respect, if Section 9 is to be given its full substantive effect, would need to also apply with life partners. So life partners would have a claim under the common law against a third party under Pashal, and as with spouses, they would have a claim under the Maintenance of Surviving Spouse Act against the executor of the deceased estate. The extent of that claim will depend on all the factors which need to be applied.
Mr. Stelzner, if I may.
Yes, thank you, Justice.
Thank you.
Thank you, Justice.
You speak of, or we speak of, a contractual right of persons in life partnerships. Now, how realistic is that right, and how enforceable is it in the lifetime of the partnership, in the lifetime of the partners? Isn't there a distinction then that there's an advantage to have one partner deceased, so that this claim becomes, the claim on the basis of contract can be activated, but in the lifetime of the parties, is it enforceable realistically?
Yes, Justice Pillay, I assume the question is, what do you do when you, yes, go to the maintenance court and claim maintenance, whether you're entitled to that under the Maintenance Act? That is, yes, a situation which I assume would have to be dealt with under the Maintenance Act. I don't know whether there's any legislative amendment there to deal with life partners. But just as far as legislation is concerned, there are a number of provisions, as we know with the Judges Remuneration Act, for example, where the legislature has provided for the same rights to life partners and heterosexual life partners. There's also the
yes, but I understood your response to my brother Jafta, that at the moment, in the lifetime of the partners, there isn't an enforceable right ex contractu realistically because, ex lege, because the Maintenance Act covers only parties who are in a formal marriage.
Yes.
So what I understand you, and correct me here, is what you're seeking is that the context between folks and now has changed. The change being that it is now societally recognized, and the legislature has, in the form of the Law Reform Commission, started to recognize that there needs to be some kind of recognition of the rights of vulnerable partners in partnerships that are not akin to, or not marriage relationships, but something else. Yes. That's what you're seeking. And what you're seeking, if I understand correctly, is that the default position should be, well, to this limited extent, where partners have a duty of support. Is that all you're seeking in this process?
Indeed, Justice Pillay, and it's also post-death. So that is the distinguishing factor. The position of life partners during the existence of the partnership for maintenance ex contractu under the Maintenance Act is something that's not before the court. It's all post-death, and it deals specifically with the position of someone post-death. So it doesn't deal with pre-death, but it also doesn't deal with, let's put it in inverted commas, divorce, post-separation. And those are the other complications that are, and future incremental issues which may need to be considered if the legislature doesn't deal with all of those. But yes, those issues are not before the court. And just if there is a concern about unintended consequences, one has the precedent in the orders of this court. For example, the Constitutional Court judgment of Acting Justice Van Heerden in Gorey versus Corbin, where there is the qualification. And then there's also the limitation on retrospectivity. And although you cater for the applicant's specific position, in Gorey versus Corbin, the court below said that it doesn't apply to estates which have already been finalized. The Constitutional Court said it doesn't apply in the case where transfers have already been effected of property and bona fide without knowledge of these issues. So there are those limitations. And then in those cases, there's also the provision that the parties can approach the court if there are consequences which are not foreseen. So there are precedents for dealing with whatever other eventualities may or may not be out there, and whatever administrative challenges and concerns and effect this may have on the rights of others. But the fact of the matter remains that an individual and other individuals in the same position as the applicant are, with respect, entitled to this protection under Section 9 and entitled to these benefits. So we're not trying to take away benefits from anyone who's married. We're simply trying to ensure that the same applies to those who nearly got married.
Thank you, Mr. Stelzner. You've answered me.
Thank you.
I'm sorry, I'm confused now, Mr. Stelzner, and correct me if I had thought you earlier on said the impugned provision doesn't create a new right which did not exist. It preserves an existing right. But now your last submission seems to suggest that in some cases, it should be construed as creating a new right that did not exist. Forget about the position during their lifetime. Don't look at that. Don't look at whether there was any right to enforce then look at only the stage after death. And that's where I'm getting confused. I thought you had agreed with me that what the section does is to preserve and change, and you gave substantial answer to it. You said, at common law, when one of the parties to a marriage died, the right fell away. So what this act did was to preserve a continuation of that right upon death to married couples. Now, I'm getting confused now if we are to say, well, forget about whether between the lifetime partners there was a right or not. Forget about that. Just focus on the period after death. And that is when the section kicks in, as if it creates a new right. So that, I still have a problem with that, but I had your submissions.
Justice Jefter, sorry, we stated at the outset that a requirement for this right is that there be a life partnership, and a requirement for a life partnership is that there be a reciprocal obligation of support during the lifetime, and that must be there ex contracto. My answer to Justice Pele's question was, well, how does one go about enforcing that ex contracto right, for example, in the maintenance court? And I think that the Maintenance Act would need to also be declared unconstitutional for that to happen, but one can enforce that contractually. It's like any other contract, and whether it's tacit or express or in writing or oral or through conduct. If the one party undertook to support the other party for an indeterminate period or fixed period, well, if those are the terms of the contract, one can go and enforce those. So we during the lifetime, but this case we say is to deal with the situation post death of one of the partners, and we say it must be the same, whether you're married or not, because the Interstate Succession Act and the Maintenance of Surviving Spouse Act shouldn't discriminate between people on the basis of marital status. That's an express prohibition. And if someone wants to say, well, it's fair, well, then the onus is on them to prove that. If someone wants to say it's a legitimate limitation under Section 36, then they must come and prove that, and say that. But no one says that in this case. The department, the third respondent, they're not trying to justify this differentiation. All they're saying is that they're past decisions of this court, which decided these things in a certain way. So those are our submissions. We pin our colors firmly to the mast, as anyone who's going to rely on a life partnership will have to do, and that is that there must be a legal obligation, contractual obligation, to support the partner during the lifetime.
Mr. Salsa, I have one final question, please. If the matter as between the applicant and the executor is moot, why should this court hear the matter? This is in relation to the maintenance claim, I'm sorry.
Yes.
What benefit does the applicant herself gain from a decision of this court if you were to find in her favor?
And I must concede, Justice Strawn, the fact of the matter is that because, and if the applicant was entitled to inherit everything, well then the maintenance, under the Maintenance of Surviving Spouse Act, would not have had any practical effect for her. So the answer, as far as the applicant specifically is concerned, is that if the Interstate Succession Act provision is and the invalidity there is confirmed, then the fact that she compromised her claim financially and only took 3 million rands instead of whatever other amount she could have got, Well, that doesn't render the whole issue moot. There's still a requirement of confirmation of illegality and invalidity and the constitutionality, and the second respondent, the executor's interest in the matter, and the master's interest and finality and a decision in principle on this point. So there's no mootness as far as the Interstate Succession Act aspect is concerned, but as far as the applicant is concerned, Justice Strong, I must concede that because she was the sole heir under intestacy, if she had presented a claim, well, then the executor would simply have said, well, I'm paying you everything under the Interstate Succession Act. There's no more money in the estate and you're getting enough to look after your own needs. So you don't have a claim. So the second leg of the case is one which deals with the approach of this honorable court in a number of cases. I think going back to the ordinary court-martial case referred to in Kruger versus the President of the Republic of South Africa, the Union of Refugee Women case. There's the Independent Electoral Commission versus Langeberg Municipality, and the DPP Transvaal versus Minister of Justice. And those cases say that mootness is not only relevant to the lists between the two parties. If there are other members of the public out there to whom these issues are indeed relevant, then the court, in the exercise of its discretion, and being the constitutional court, we respectfully submit to important constitutional matters such as this, in circumstances such as these, where the other parties, the amici, will we respectfully submit in due course, show that there are other people who are affected by these issues and the Maintenance of Surviving Spouse Act, in addition to the Interstate Succession Act. And then the other problem is that there is a judgment of this court, which this court has already indicated it will revisit on the right facts, and that is the case of Folks versus Robinson. And when the time comes, the court will reconsider the decision in that case, and for the constitutional reasons identified in Loubser versus Duplan. So the short answer, once again, Justice Tron, is that apart from the applicant, in respect of whom the Maintenance of Surviving Spouse Act issue may be moot, or is moot, there are all the other individuals represented by the amici in this case who have a direct and substantial interest in a decision of this court on the Maintenance of Surviving Spouse Act's constitutionality. So the balance of the claim is not really that of the applicant, but the amici, I think, will address the court on that aspect. So those are our submissions there. And then one final aspect, unless there are further questions, is that in the order that we are seeking, we're asking for the costs of this application. But what we omitted to include in the draft order is also that the costs of the applicants, counsel and attorneys in the court a quo also be included in the confirmation order if this honorable court is prepared to make a confirmation order as far as the Interstate Succession Act aspect is concerned. As far as the Maintenance of Surviving Spouse Act issue is concerned, the question there is whether it's a matter of public interest to such an extent that the court will enter into that issue in the exercise of its powers and discretion to do so. Those are our submissions.
Thank you, Mr. Stelzner.
Thank you, Chief Justice.
Colleagues, may we adjourn for 10 minutes?
As the court
Court
pleases.
will adjourn for 10 minutes.
Court will adjourn until 12 o'clock midday. Please note that during the adjournment, you're welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 12 o'clock midday. Should you exit, you may use the same link to rejoin the hearing.
Thank you. Jetzt kann man nicht los. Video.
All right. I'm back again. Thanks a lot, Sunil. All right, sure.
You have reached mailbox number 0.
LT, are we all back in?
I think we are, Chief Justice.
Chief Justice?
Including counsel.
Yes. Chief Justice and Justices, all counsel are online.
Thank you. Ms. Christian?
I'm here, Chief Justice.
Yes, please go ahead. You have 5 minutes without interruption.
Thank you, Chief Justice. The Women's Legal Centre's position in this matter can be summarized as follows. The Women's Legal Centre agrees with the applicant that insofar as the Intestate Succession Act and the Maintenance of Surviving Spouses Act does not provide benefits to partners in a permanent opposite-sex life partnership who have also undertaken reciprocal duties of support, those acts are discriminatory, unconstitutional, and invalid. The Women's Legal Centre also fully supports the High Court's finding that the relief granted in this matter should not be limited to the partnerships where there had been a commitment to marry. Where we disagree with the judgment, however, is that by not granting the relief in respect of the Maintenance of Surviving Spouses Act, the High Court did not go far enough. The Women's Legal Centre also urges this court to consider the issues raised in this matter from two distinct perspectives. The first is from the point of view of women who feel the effects of discrimination more harshly than men do. And second, by appreciating the intersectional nature of the discrimination experienced by women affected by that discrimination. In other words, because the reasons for not marrying are vast, and because different women may experience the effects of their partnerships ending in different ways and in different degrees of severity, depending on any one or more of the following factors. As I've already indicated, simply because of their gender, they feel the effects of the discrimination more harshly than men do. Other relevant factors are also race, social and economic circumstances. And at this point, it bears mentioning, I submit, that the first two of those factors are recognized forms of unfair discrimination, whether it be direct or indirect. And so I submit that it is an important factor to take into account when considering whether the benefits of the Intestate Succession Act and the benefits of the Maintenance of Surviving Spouses Act should be extended to opposite-sex life partnerships. The assistance the Women's Legal Centre brings to this case is by presenting evidence of its own experience in encountering women who seek assistance when their life partnerships terminate. And that's their experience is based on whether the termination is by death or separation. But of course, in these proceedings, we're concerned mainly with the effects upon death of one of the partners. And the particularly harsh effects of non-recognition of life partnerships upon death is illustrated in 3 out of the 20 case studies that have been presented. And that's case study number 1, 14, and 17. I submit the remaining cases involve partnerships that were ended while both partners were alive, and in 1 or 2 cases, the relationship was still in existence. But the facts of those case studies, I submit, remain relevant because they illustrate the reality of life partnerships in South Africa and how the absence of remedies when those relationships end affect women in particular. The evidence presented by the Women's Legal Centre is also supported by extraneous evidence in the census results that have come out since 1996 up until 2016. For purposes of this, my apologies, the census results from 1996 to 2016 show that over the 19-year period under consideration, the number of people who identified themselves as being married has consistently declined, And by contrast, the proportion of cohabiting persons, in other words, life partnerships that are under consideration in this matter, have increased from 1996 to 2016. And in numerical terms, the number of cohabiting partnerships has almost tripled from 1996 to 2011, from around 1.2 million in 1996 to over 3.5 million in 2011. I do concede that there appears to have been a slight decrease in 2016, but I'd caution that the 2016 results were as a result of a community survey rather than an official census. And so against that background, the Women's Legal Center and I submit that while the legislation under consideration is framed in neutral terms, the realities shown by the results of the census illustrate the indirect discrimination caused by that seemingly neutral legislative choice. Over the course of the three censuses, the percentage of cohabiting respondents among African and Black population has increased. And in 2011, for example, 3 million or approximately 3 million of the total 3.5 million cohabiting respondents were of African and Black descent.
Ms. Christian, the 5 minutes has expired.
Thank you, Chief.
Yes, but continue.
Thank you, Chief Justice. That evidence finds further support in the South African Law Reform Commission report in 2006 on domestic partnerships. And that evidence was also presented by the Women's Legal Center in the High Court and forms part of the record in this court. And that report confirms the harsh realities faced by women in life partnerships in the South African context. And the report observes that while living together is a middle-class choice in a number of developed countries, in South Africa, it is a real problem outside of the control of most poor women. And the reason I highlight these aspects of the evidence before this court is to illustrate that the facts now before this court that wasn't available at the time of Folks versus Robinson was decided justifies a reconsideration of the position established in that judgment. The evidence of the Women's Legal Center, in addition to the quantitative illustration of the existence of life partnerships in South Africa, also highlights some of the reasons couples live together without getting married.
Ms. Christians, the court in Folks might not have been aware of the detail which you've now given us, and which besides your client's evidence, you say is also illustrated in the SALRC report. The court might not have had the benefit of the detail, but I do not think that the reality was lost to it, that there are problems. Problems may sound like a euphemism perhaps, but you know what I mean. Yes, and indeed, as Justice Theron, my sister Justice Theron indicated, towards the end of the majority judgment, the court does highlight the fact that it was aware of the problems. So based on how it reasoned, I doubt that the detail that you are giving us would have influenced it otherwise. I have my doubts about that.
Justice Madlanga, my response to that is that the additional evidence, it is relevant insofar as the Women's Legal Center.
I'm not, no, don't misunderstand me. I'm not suggesting that the evidence is irrelevant, not for a moment. But I understood you sort of to be suggesting that because the court in Folks did not have that evidence, I thought maybe the subtext is that maybe it would have decided differently if it had that sort of evidence.
Justice Madanga, I submit that if it was brought to the attention of the court just how pervasive the problem is, and particularly when the South African Law Reform Commission itself, which is an organ of the state, highlights the reasons behind why parties don't marry, even though the notional choice is available to them. I submit those factors might have influenced the court in Fawkes to come to a different conclusion. And I say that specifically because the court in Fawkes excluded the evidence that was sought to be tendered by the amicus in those proceedings on the basis inter alia that it wasn't uncontrovertible. And in these proceedings, the Women's Legal Centre has sought to present evidence that is incontrovertible by backing it up with the statistics of how the prevalence of life partnerships has increased since the judgment in Fawkes. And then also because the South African Law Reform Commission conducted an extensive...
So amongst others, you're basically saying faced with that reality, the court could not realistically have said there is a choice.
I submit that with respect to that, there is a strong possibility that the court in Fawkes might have reasoned differently when faced with all the evidence presented in this matter. And then a further relevant factor, which I submit must be considered together with the additional evidence, is that the law itself has changed since Fawkes' judgment. So the new evidence must also be viewed in the context that the law in relation to life partnerships as it applies to same-sex life partnerships has changed. And so as Justice Froneman in the concurring judgment in Loubser and Duplant points out, that I beg Justice Malanga's pardon, I lost my train of thought there for a moment. The development of the law is relevant insofar as the enactment of the Civil Unions Act has undercut the rationale that informed the decision in Fawkes versus Robinson. And so when one looks at the realities and the development of the factual situation in South Africa, together with the legal development, if the court in Fawkes versus Robinson were to sit today and reconsider it on the same basis, I respectfully submit that given the rationale in Gorey versus Culver and in Loubser versus Duplant, the court hypothetically hearing Fawkes versus Robinson today would be constrained to find differently than it did in 2004.
Ms. Christians, where does that leave us insofar as judicial precedent is concerned? As I understand your argument is that as at the time Fawkes v. Robinson was decided, it may have been correctly decided. But now the law has changed. Now, do we depart from it on the basis of the change in the law? Or do we depart from it on the basis that it was clearly wrong? So which of the two should we follow?
Justice Drafter, my respectful submission is that this court should depart from Fawkes versus Robinson on the basis that the law has changed since then. And the reason I say that is, again, one can't look at the changes in the law in isolation from the changes in the factual realities of life partnerships. And the reason I say that is when Fawkes versus Robinson was decided, there was no conflict in the reasoning there with a judgment like Gorey versus Culver. And at this point, I'll highlight that ironically, or not ironically, correctly so, the court in Gori versus Corver acknowledged that the remedies it crafted for same-sex life partnerships would not be available to the partners in life in opposite sex life partnerships. And for that statement, it relied on Folks, on the binding precedent in Folks. And so I submit that Gori versus Corver correctly identified that because of the reasoning behind both judgments, the rationale in Folks applies equally to the Intestate Succession Act as it does to the Maintenance of Surviving Spouses Act. And when one considers that, I submit it's no longer possible to distinguish the case as it applies to the Intestate Succession Act, because one must look at the reasoning behind the judgment in Folks versus Robinson and in Gori versus Corver and appreciate and accept that the underlying reasoning, the duty of support, applied in both cases. The only difference was that in Folks versus Robinson, Mrs. Robinson had a choice on whether or not to marry, and Mr. Gori in Gori versus Corver did not have that choice. And so based on, I submit, the discrimination that was felt in the same-sex partnership community, the court decided that the failure to extend the rights of intestate succession to partners in same-sex life partnerships was unjustified. And that judgment was passed shortly before the Civil Union Act was in fact enacted. And the court was cognizant of the fact that that legislation was imminent. And notwithstanding the imminent legislation, the court in Gori versus Corver made the decision that because of the factual duty of support that existed between life partnerships, those life partners were entitled to benefit under the Intestate Succession Act. And so where the court found itself in 2016 with Loubser versus Duplan was the flip side of today's argument, where the parties there were arguing that because of the enactment of the Civil Unions Act, the extra benefit that partners in same-sex life partnerships enjoy must be removed. And this court categorically said no, and instead elected to equalize up, as it called it. And so the benefits that apply to same-sex life partners now apply whether or not they are married, even though they have the choice to marry. And so given that development in the law, I submit that this court can relook at Folks and say, this disparity didn't exist when Folks was decided. It does exist now. And so we are justified and required to move away from the reasoning of Folks. Justice Jafta, I hope that has answered.
Yes, no, it does. But what worries me is the reference to the Interstate Succession Act. I thought we're dealing with the Maintenance of the Surviving Spouse Act with reference to Folks v. Robinson. And as I indicated earlier, speaking for myself, I have no problem in confirming the declaration of invalidity. The only reservations that I have relates to the Maintenance of Surviving Spouse Act. So I heard you, but I thought, reference to the Interstate Succession Act was not really on point. But I heard you on the other points. But can I just clarify this? All this, these submissions that you are making, for example, in relation to the impact of the discrimination to a vulnerable group of people, women.
Yes.
They are limited to the case at hand. That is a case where there is life partnership, where there has been reciprocal rights and duties of support.
That's
Do I
correct.
understand that?
Absolutely, that's correct, Justice Jafta.
Okay, thank you.
Critical issue in determining whether the life partnership in question is deserving of legal protection, and that is whether or not the parties have undertaken reciprocal duties of support.
Yes. Yes. So that it's not aimed at all life partnerships, only those where the parties had undertaken reciprocal rights and duties.
Indeed, Justice Jafta, and that in the cases where the benefits have been extended, that has always been the qualifying criteria.
Even though it doesn't mean that women in life partnerships where there is no element of reciprocity are not feeling the discrimination. They do feel it. But for present purposes, we shouldn't worry about that. We should look at it in the context of where there has been reciprocal rights and duties.
Indeed, that's correct, Justice Jafta.
Let me, Ms. Christians, let me take you back to the evidentiary matter that you've highlighted. Am I mistaken that the minority judgments in Folks v. Robinson actually highlighted the realities that the evidentiary material now puts beyond question? Is it not so that the minority judgments, one by Justice Sachs and the joint one by Justices Mokgoro and O'Regan, actually highlighted the realities? There isn't really choice, and so on and so on and so on.
Indeed, Justice Madlanga, specifically in relation to the minority judgment of Justice Sachs, he highlighted the impression, however, that I got from the judgment is that judicial notice was taken of those facts rather than it being based on firm evidentiary material before the courts. And judgments that have previously acknowledged the plight of women. And so differently to this case where there's quantitative and qualitative evidence of the pervasive nature of life partnerships and the suffering felt by women in particular, the court wasn't faced with that evidence, but it did acknowledge the reality to a certain extent.
You see, why I'm asking that is I want to establish to what extent your point that there is now somehow a change, to what extent is that valid? Because if the court was aware, the majority that is, but it was more a case of them just not accepting that and saying, marriage is this very important institution and so on and so on and so on. So it wasn't really a case of them saying, we are not going to accept this coming as it does from our colleague Justice Sachs. They were not saying that. So why am I raising that? I'm raising that to say, I'm not altogether sure that it's convincing for you to say, now that we have this coming from witnesses, it means there is a change. And therefore, based on that, we don't need to say Folks v. Robinson was wrong, but we must only say circumstances have since changed. Have they? I guess the subtext of what I'm saying is, doesn't this bring us closer to just having to look at Folks v. Robinson in the eye and decide, was it wrongly decided or not? Yes, of course, there is the second leg of yours about the legal development, but now I'm texting you just on the question of facts or evidence.
Justice Madlanga, as far as the facts go, the the two discerning factors of the evidence here that I say is significant is that the increase in the prevalence of life partnerships has increased significantly since Folks. So while it applied to 1 point something million when Folks was decided, today in 2016, it's over 3 million. And I submit that that is a relevant factor to take into account when deciding whether or not the picture that was before Folks versus Robinson is the same as it is today.
I'm not sure of the correctness of that as a legal or a constitutional principle. If something is unfairly discriminatory as a matter of constitutional law, it is so whether the affected people are 3 or 30 million. So I don't get that point at all.
I take Justice Madlanga's point. And the second aspect that is also relevant, I submit, is the steps taken by the Law Reform Commission since Folks versus Robinson. And the categorical acknowledgement by an organ of state that recognition is required because it has a discriminatory and harsh effect on women. And related to that point, I submit, is that the majority in Folks versus Robinson was, to a large extent, I submit, influenced in their decision to be deferential to Parliament by the fact that Parliament had indicated that legislative reform was imminent. And that approach, I submit, is similar to the situation with regards to Muslim marriages, where initially the courts were deferent because there was an indication from the state that legislative reform was imminent. But now 2 decades have passed since then, and it appears that the legislative process has started completely afresh. So there is no promise and no carrot dangling before this court to say that legislative reform is imminent and so it must exercise judicial restraint. And I submit that that is also another factor that is relevant to the question whether this court should depart from Folks versus Robinson.
Ms. Christians, if I could just explore a little more further the aspect that my brother Justice Madlanga was with you a few minutes ago. If you look at paragraph 119 of the Folks judgment, that's the judgment of Justices Mahoro and O'Regan, if I'm correct. They were quite aware of the fact that more and more people in South Africa were living together without being married. They had statistics from 1991. They had a census in 2001. So in 1991, the statistics showed that the number of people living together as cohabitants had grown from 463,000 in 1970 to 1.2 million people in 1991. The 2001 census showed that 2.3 million people described themselves as living together like married partners. So the fact that 15 years later, there would understandably be more couples, I'm not sure whether as much weight can be attached to that as you suggest. The judgment, and especially the judgment of Justice Sachs, was mentioned the legislative changes regarding the recognition of domestic partnerships. And this is at paragraph 175 of the judgment. And Justice Sachs refers to, he says, since 1994, a flurry of statutes has recognized domestic partnerships. These include Medical Schemes Act, the Prevention of Domestic Violence Act, the Housing Act, the Compensation for Occupational Injuries Act, in paragraph 176, the Employment Act, the Promotion of Equality and Prevention of Unfair Discrimination Act. So already at the stage when Fox was decided, there were already legislative changes that the court took into account.
Yes, Justice Turan, I appreciate that there were legislative changes aimed at specific instances and rights that would flow from life partnerships. The difference I submit with the changes that occurred subsequent to the judgment in Gorey versus Culver and the enactment of the Civil Unions Act is because the rationale in Gorey versus Culver was very similar to that in Fultz versus Robinson. And in Gorey versus Culver, as I've mentioned earlier, the court at paragraph 29 says, depending on the nature and content of the new statutory dispensation, if any, there is the possibility that unmarried heterosexual couples will continue to be excluded from the ambit of section 1.1 of the Act. And the footnote uses as authority for that proposition, Fultz versus Robinson. And I submit that by making that observation, the court in Gorey versus Culver acknowledged that the principles that would apply to the Maintenance of Surviving Spouses Act would apply equally to the application of the Interstate Succession Act as it applied to heterosexual life partnerships. And so that it's for that reason that I submit that the legal changes, the changes in the legislature together with the court jurisprudence justifies the law sufficiently changed that the judgment in Fultz versus Robinson should no longer be followed.
Ms. Christians, may I ask you, just as a point of information, in the domestic partnership bill, which has never made any progress, it seems, in section 18, you mentioned that there is provision for maintenance during a course of a life partner's lifetime. Does that bill make provision for a maintenance after death of a life partner?
If I can, off the top of my head, I can't recall.
In other words, what I'm asking is, does that bill envisage extending this act, the MSSA, to this kind of to life partnerships?
I will have to just.
Well, you could always deal with it later then. Thank you.
Thank you, Justice Majid. But what I will say, however, is that it appears from the new discussions that the South African Law Reform Commission has undertaken that two completely different bills are now being proposed. And so the domestic partnership bill that was proposed back then doesn't appear to have any prospects of being passed. But I will endeavor to get back to you on that particular point. Chief Justice, I just was wondering whether the time I have allotted has run out, or if I may continue with the address.
It has, but we put questions to you, so just indicate whether you still need more time and proceed on the understanding that as colleagues put questions to you, that will not prejudice your opportunity to put your views across.
Thank you, Chief Justice.
Ms. Christian, you mentioned that there's a new discussion paper that was published in January this year.
Yes, that is.
Now, that process, I'm aware, I'm mindful of the fact that the initial bill was published in 2008, almost 13 years ago, and nothing came out of it. Now that we are aware of this discussion paper that is on the table, why should we not allow that process to take place?
With respect, the simple answer to that is that the same proposition was put to this court in Fawkes versus Robinson, and it's been 16 years later and nothing has been done. And as I've submitted in my heads of argument, the fact that the minister has now referred to this new process that is underway doesn't guarantee that anything will be done, and if anything is done, we have no guarantee of the time frame that that will take. And also significant to that is the fact that the minister, contrary to the position that was taken in Fawkes versus Robinson, has not asked this court to exercise judicial restraint because of that process that is underway.
Is there anything that the interested parties could do to compel a National Assembly to act with speed in the matter, besides asking the court to legislate on this particular aspect?
Justice, unfortunately, this problem is a vexed one, and it has come up in the case of the Muslim marriages. And recently, in December 2020, the SEA expressly refrained from confirming the High Court's finding that Parliament in that instance, and the state in general, was required to enact legislation, and that is in respect of Muslim marriages. And so given that the high hurdle that it would require to compel the state to enact legislation, absent the state taking those steps on its own, I submit there is no reasonable prospect of a litigant coming to court and asking the court to direct Parliament to enact legislation to give recognition to those rights. What the court can do, as it has done in many cases similar to this, is to recognize the discrimination and consequently the unconstitutionality of under-inclusive legislation, and to extend those benefits where it is just and equitable to do so. As that,
Are you suggesting, Ms. Christians, that if we are with you on the issue of invalidity, we can declare the act invalid to the extent that it is under-inclusive and give Parliament a fixed period within which to remedy the defect?
Justice Drafter, that is one of the powers that is in this court's purview to take. That's what was done in the case of Fari. But with respect, because of the development of the law in Gori versus Culver and in Loksha versus Duplan, I would submit that in the interest of consistency and applying an approach that is equal to all, it would be preferable for this court to give a reading in order that extends the application of the Maintenance of Surviving Spouses Act and the Intestate Succession Act to partners in a life partnership.
Yes, but if we find that the reading in here might create other problems, shouldn't we follow the conservative route of a declaration of invalidity and allowing Parliament to cure the defect?
Justice Drafter, I would agree with that proposition if this court finds that the law in respect of intestate succession is distinguishable from the position in respect of Maintenance and Surviving Spouses Act. And if the court were to take that approach, and notwithstanding the difference in legal jurisprudence, distinguishing the two acts, were to find that the Maintenance and Surviving Spouses Act was unconstitutional, then one of the possible appropriate remedies would be to direct Parliament to cure the remedy within a specified period of time. And I would add that it would be appropriate to impose a default remedy if that were not done. On the other hand, as regards the Intestate Succession Act specifically, because of the express development of the law of that act to include life partners who are in a same-sex relationship, I submit that no purpose would be served to differentiate between same-sex and life partnerships on that basis and to direct Parliament to cure that defect when a reading in was done in Gorey versus Culver and confirmed in Mercer versus Duplan.
Well, my concern is really in relation to the maintenance claim, not the other one.
Yes,
but I get what your submission is.
One, just on the topic of distinguishing the Maintenance of Surviving Spouses Act from the Intestate Succession Act, it might be helpful just to have a thought experiment, as it were, to imagine that Mr. Gorey wasn't the sole heir in that case, and that he also, in addition to being entitled to inherit from the estate, also required maintenance. And I submit, if one has regard to the rationale of this court in Gorey versus Culver, and based on the reasoning that it extended the rights in the Intestate Succession Act, I submit that that court would have extended those same rights in respect of the Maintenance of Surviving Spouses Act, notwithstanding that Fawkes versus Robinson had been handed down just over a year earlier. And so again, on that basis, I would emphasize that the rationale between the two cases are inextricably linked. And so my submission is that they must both be treated equally. And if the Intestate Succession Act is to be extended, then likewise the Maintenance of Surviving Spouses Act must be extended.
Was Gorey decided before or after Pashal?
It was decided before Pashal. Pashal was a failure development.
Doesn't Pashal makes a difference?
Justice Draft, I think Pashal adds support for the submission that I have made, that the extension of benefits that flow from Gorey are equally applicable in respect of the Maintenance of Surviving Spouses Act. The Commission for Gender Equality will make further submissions on the exact extent to which they submit Pashal has extended the common law. But what I will submit is that the development of the law there was to recognize an enforceable legal duty of support between partners in a permanent life partnership. And so it recognized that the support wasn't merely a contractual one, but it was one that it was enforceable against the partner who happened to have died. And it extended the right that was ordinarily permitted to spouses in marriages, to spouses or partners in permanent life partnerships. And by doing so, it recognized the legal force of that undertaking to provide reciprocal support. And so for that reason, I submit there's no logical reason why the extension of maintenance beyond death should not follow pursuant to the judgment in Pashal. And particularly, I'd add that it appears to me to be an illogical legal state of affairs to permit a partner of a deceased who has died to claim maintenance from a third party, but to deny them the same claim against the deceased estate. And for that, I make common cause with submissions that were made in response to Justice Jafta's query in that regard by Mr. Stelzner.
Yes, my understanding of Pashal is that the common law has to be incrementally developed. And it wouldn't make any sense in logic or principle to say the right is enforceable only against third parties. It's not enforceable against the deceased estate. I agree with you there. But the point was, which I was making, was Pashao seems to grant some remedy based on the right that existed before death. And when you look at the impugned provision of the Maintenance of the Surviving Spouse Act, it seems to me it merely says there was this right which existed up until death, and it would have ceased to exist upon death, but it will continue to exist even after death. Okay, so it doesn't really create a new right, statutory right, that was not there before. What it does is to say you will continue to enjoy your right that you enjoyed whilst your partner was alive after they had died.
That's correct, Justice Jafta.
Okay.
And so what, if I can respond, the result of the Pashao judgment then is that it developed the common law by, for the first time, acknowledging that the duty of support undertaken by members or partners in a life partnership was legally enforceable.
Yes.
And so by the same logic that Justice Jafta has explained now is what the applicant and the Women's Legal Center and the Commission for Gender Equality is asking this court to do is, on the basis that there is now recognition that the duty of support existing between life partners is legally enforceable during the life of the partner, there is now no longer an obstacle or a justification for not extending that right beyond death in the same way that the Maintenance of Surviving Spouses Act does in respect of married partners or married spouses. So that is the important link between the development of the law and Fawkes versus Robinson. In Fawkes versus Robinson, the duty of support was recognized purely as one that existed between the parties at will, whereas the SCA and Pashao developed the common law to confirm that that duty of support was one that was enforceable in the law. It was no longer just a voluntary undertaking, but one that one partner could enforce against the other during their lifetime, and then extended that duty and the right to third parties after the wrongful death of the deceased partner.
Remind me, in Fawkes v. Robinson, was the court asked to develop the common law, or that issue did not arise at all?
As far as I understand the judgment, there wasn't a request for the court to develop the common law to that extent.
Thank you.
Justices, the remainder of my address has been, by and large, covered by the questions from the bench. So unless there are any further questions, those are my submissions.
Ms. Christian, may I remind you that you were to revert to Justice Majid on an aspect, if you perhaps are able to at this stage?
I would have to just go to the record once more. So if the Chief Justice and the Justices will allow me to revert as soon as Counsel for the Commission for Gender Equality has concluded her submissions. Unless the court is willing to wait while I...
Well, let me just find out if my brother insists on you reverting to him on the matter. Justice Majid?
Well, if Ms. Christians can't find it now, we can pick it up in the bill afterwards, Chief Justice. So if she's not possible to do so now, it's fine. We could pick it up later in the bill ourselves. Thank you.
Thank you, Justice Hajat.
Okay, thank you. Thank you very much. Thank you, Ms. Christian.
Thank you, Chief Justice.
Thank you. Ms. Adikari.
Thank you, Chief Justice, Justices. Oh, my submissions will cover 4 broad areas. Firstly, I'd like to address the issue of mootness as raised by Justice Theron in her questioning of the applicant. Then I'd like to speak about the issue of separation of powers, which has arisen during the course of argument. The third aspect that I'd like to address is what is the status quo? And then I will deal with the question which is squarely before this court in regard to the decision in force. Firstly, in regard to the question of mootness and why this court should decide this matter, as this court has stated on numerous occasions, the test for leave to appeal in these sorts of matters is primarily the interests of justice. And in that regard, as this court has said, particularly in Pridwin and Pillay, the questions are basically the nature and extent of the practical effect of any order that the court may grant, the nature and the complexity of the issues facing the court, the fullness of argument in the courts below, and in particularly in Pridwin, what the court said, and which is particularly apposite in this matter, is the need to correct wrong statements of law, and very importantly, the opportunity to squarely address an important constitutional issue that will probably not be raised in this court again because of the impecuniosity of the litigants and because of the expense of appellate litigation. And the 2 cases that I referred to, Pridwin and Pillay, are examples of where the matters were moot. In both cases, they involved schools. The children in question had left the schools by the time the matter came to the court, and the court nonetheless granted leave to appeal in those matters because of the importance of those issues and because of the need to squarely address important constitutional issues at the time when a matter comes to the court. In regard to the issue of separation of powers, the question seems to have its origin in the submissions of the minister in regard to the law reform processes that are purportedly winding their way through the courts or through the legislative processes. And there are a number of answers to that question. Firstly, this court's judgment in Mazibuko versus Sisulu gives us the answer. The answer is that it is in fact no answer for the court, for the parties to say that the process of remedying a lacuna is in process. What this court must decide is there a constitutional invalidity? If there is, the court must deal with the constitutional invalidity. It must declare that there is a constitutional invalidity, and it must provide a remedy. And in this particular instance, insofar as the court may be disinclined to trench upon the terrain of the legislature, it would not be trenching upon the terrain of the legislature for the court to do what it is called upon to do by the Constitution when faced with a constitutional breach or violation. The court must declare that the violation exists. What the court must then do, particularly in this sort of matter, is to create a remedy, which may be an interim remedy. The court may then suspend the order of constitutional invalidity for a particular period of time in order to give the legislature an opportunity to remedy the unconstitutionality. And then importantly, as the court did in Fourie, to state that if the legislature does not remedy the unconstitutionality within the period of suspension, that the interim remedy granted then becomes final. And that's what the court has done on numerous occasions. And what it does is it remedies the unconstitutionality immediately. It provides relief for a vulnerable group of persons, but it also allows the court to give the legislature the space and time to correct the unconstitutionality. And if it doesn't correct the unconstitutionality, there's no need then for the impecunious litigants to once again approach the court to correct the unconstitutionality in circumstances where the legislature does not take up the invitation to remedy the unconstitutionality. I would just say one more thing on this aspect. When Volks was argued, the same argument was made by the legislature that there was a law reform process in place. We know, because we're here today, that whatever that law reform process may have been, it did not bear fruit. We know that there was a domestic partnerships bill which has disappeared into the ether, nothing has happened, and we are now told that there is a new law reform process which relates to a single marriage statute. And there may be other legislation that's being considered in regard to domestic partnerships. But the point is we don't know where that is. It's not an answer for the minister to say that there's a law reform process. If there's a constitutional invalidity, it is for the court to deal with that squarely. And one other aspect is that what we're dealing with here is different to the Muslim marriages cases, where in the Muslim marriages case, what you're dealing with there is a failure to legislate. And as a consequence of the failure to legislate, there is an unconstitutionality. What we have here is the opposite. We have an unconstitutionality that arises as a consequence of an act, an existing act. And it's important to note that this existing act was brought into play because the court, the appellate division in Glazer versus Glazer back in, I think, 1967, made a determination that under the common law as it stood at the time, spouses after death did not enjoy an enforceable right, an enforceable duty of support after death. The legislature recognized that lacuna and then brought this piece of legislation into fruition. And so what we have here is an unconstitutionality which arises from an existing piece of legislation. It's different to the Muslim marriages case. And then to move on to the status quo, and the first thing I'd like to address is the question put by Justice Pillay in regard to the Maintenance Act. Section 2.1 of the Maintenance Act currently provides that life partners during the existence of the partnership are entitled to claim maintenance. And I think the words of the Maintenance Act are very clear. Section 2.1 of the Maintenance Act of 1998, it states that the provisions of the Act apply in respect of the legal duty of any person to maintain any other person, irrespective of the nature of the relationship between those persons giving rise to that duty. So hopefully that puts paid to the question of whether or not there's an enforceable duty during the lifetime of partners insofar as the ability to claim maintenance is concerned. And then moving on to the question of the status quo and what the law currently states. Pashao is in fact the answer to
the 5 minutes has expired, Mr. Ricari. So continue, but colleagues may put.
Thank you, Chief Justice. So really, before I move on to what the status quo is, I would want to say just one thing about the purpose of the Maintenance of Surviving Spouses Act. The Maintenance of Surviving Spouses Act protects a very specific class of persons. It protects women. Yes, it protects spouses, but because of the structural inequalities in our society, the aim of the Act is to protect women. And the reason is because men are often the breadwinners, most often the breadwinners, and generally that gives them both the means and therefore the obligation to support their spouses. Secondly, it's women who have a need for maintenance after the death of their partners and who cannot meet that need for maintenance out of their own resources. So we're talking here about women who suffer relationship-induced destitution. It's a very specific class of vulnerable women that this Act aims to protect. And I would ask the court respectfully to bear that in mind when we are dealing with what the law says and what we should be doing, because what we're asking the court to consider is the law as it stands makes a choice. It chooses to protect a particular class of vulnerable women, a particular class of women who suffer relationship-induced destitution. And that class of women are women who are married, be they under the Civil Unions Act, be they under the Marriage Act, or be they in religious marriages. And what we're saying is that if you find yourself in a permanent life partnership akin to marriage in every other way, if you suffer relationship-induced destitution as a consequence of the death of your partner, we as a society make a choice not to protect you, not to help you. And that, with the greatest of respect, is not a constitutionally appropriate or defensible choice. And so moving on to what the law says and why it's important that we look at Pashal, because this court is being asked to look at folks. The court is grasped with folks. And the question is, well, does folks stop this court from helping this vulnerable class of women? And the answer is no, for the very simple reason that the law has developed since folks. So it is not necessary for this court to find that folks was wrongly decided. What this court is being asked to do is to decide the question on the basis of the law as it currently stands. And the basis of the law as it currently stands is Pashal. The question that arose in folks and the underpinning of the decision in folks was that the duty of support in marriages arose by operation of law, whereas the duty of support in life partnerships arose as a consequence of agreement. That has now changed, and Pashal has changed that. And what Pashal effectively dealt with was the dependence action. And the dependence action is an action which a dependent partner, spouse, has against a third party, and in circumstances where the third party has wrongfully caused the death of the breadwinner. But in order to establish that you are entitled to the dependence action, what you must first establish is that there was a duty of support on the part of the breadwinner during the lifetime of the parties, or during the lifetime of the breadwinner, that the duty of support was legally enforceable, and that the dependent's right to maintenance warrants protection of the law. And that determination is based on the boni mores of society. And so that's what Pashal did. Pashal looked at a variety of relationships, and Pashal took into account, and I would ask the court perhaps just to have regard to what the court in Pashal says at paragraph 31 and onwards. The court there deals with the nature of relationships in South Africa, and the court recognizes the fact that the majority of persons in South Africa are unmarried as opposed to married. The majority of persons who are in permanent relationships are not married. They are in permanent life partnerships, and that largely is a remnant of our past shameful history. It's a remnant of migrant labor. The reason being that people were forced to leave their homes to go and work in the towns, to go and work in the mines. And because of apartheid, they couldn't bring their partners with them. But there's an inherent human need to form relationships. And that's what people did. They formed relationships. And those relationships fulfilled the role of a marriage, the consortium omnis vitae. That's what those relationships are. And the question then is, well, do those relationships also give rise to a legally protectable duty of support? And the answer that the court came to in Pashal is yes. And while it is correct that Pashal looked at the duty of support firstly in regard to the issue of contract, but it didn't decide it on the basis that there was a contractually enforceable duty of support, because what the court says is that it's irrelevant for the purposes of the dependence action whether there was or was not an agreement between the parties during their lifetime. What is relevant is, and I will read what the court says, is that Put another way, the appellants had to establish not only that they had an enforceable agreement against the deceased, but that the obligations created by the nature of their relationship were worthy of the law's protection. And the court then says that that determination is made by reference to the boni mores of society. So what the court in fact in Pashar decided was that there is an legally enforceable duty of support which arises during the lifetime of the parties as a consequence of the nature of the relationship being a permanent life partnership which is akin to marriage. And as a consequence of that, there is a legally enforceable duty of support. And once the court accepts that, then one of the key underpinnings of folks falls away, because it is no longer the law that life partnerships do not give rise to legally or ex lege duties of support. Life partnerships now do give rise to ex lege duties of support. And if that is the case, and we ask the court to find that, if that is the case, then the court is not departing from faults. What the court is simply doing is deciding pretty much the same case as Folks, but on the law as it currently stands.
Ms. Adhikari,
Justice Jafta.
I'm a bit worried. The court might have said, insofar as the enforcement of the right after death is concerned, the boni mores of society comes into play, that I accept. But for it to say that the origins of that duty is merely the lifetime partnership, I have difficulty with that conceptually. My understanding of it has always been that that lifetime partnership, in the eyes of the common law, is regarded as a contract, which can come into being either through the means of agreement expressly or tacitly, looking at the conduct of the parties. Now, conceptually, has that kind of thing given rise to the duty of support and not being recognized as contractual? I have difficulty there. Can you help me?
Justice Drafter, the court was specifically asked in Pashar to limit the extension to people who had made a promise to marry. And the court said that that would be an arbitrary distinction. And
No, I understand that. That reasoning I understand. To men, it cannot be restricted to cases where there's an express agreement. There may be cases where the agreement is tacit. You look at the conduct of the parties and you say, from the conduct of the parties, it is clear that a lifetime partnership came into existence. So I understood the reasoning to be along the lines, no. Don't confine it to the cases where there's an express agreement, because we know in our law that contracts come into being tacitly as well. So you can't say it is only where the parties have expressly agreed. But I didn't understand the court to say, no, forget the issue of contract altogether. It is a kind of conduct in our law that is recognized to be giving rise to a duty of support, which is not pegged on contract. I have difficulty with that.
I understand your question, Justice Drafter. And the answer to that is one needs to look at what do the courts look at to determine whether or not a life partnership, in fact, a life partnership akin to marriage. And it's very specific. It's a life partnership akin to marriage. We're not here talking about other kinds of partnerships. It's a life partnership akin to marriage. And what the courts look at in order to determine whether such a partnership has come into existence is firstly the nature of the relationship. So the marriage-like or conjugal nature of the relationship, the duration of the marriage, did they share a household, did they have children together, whether they contributed to raising each other's children. The other factor that the courts look at is whether or not there was in fact an undertaking of reciprocal duties of support. How did that play out over time? The financial interdependence of the parties upon one another, the contents of their wills. And a third factor that the court looks at is the community perceptions of the relationship. Were the parties regarded by others in the community as being part of a committed family? And then also their respective marital statuses. Now, these are not factors which a court looking at to determine whether a contract has come into existence would ordinarily come into play. These are very different societal factors that the courts look at to determine whether a life partnership came into being. So I have with respect, a difficulty with conceptualizing a life partnership as a contract which is transactional in nature, as opposed to a life partnership which is much more than that. It plays a particular role in society. It is not just an agreement to live together. It is an agreement to share your life together. And that's very different to a contract. I don't know if that answers your question, Justice.
It does to some extent, but I don't think you and I are far apart. The issue is this: you're talking about reciprocal undertaking to support one another.
Yes.
That is terminology of contract. It may be a contract of a special nature. And correct me if I'm wrong, didn't marriage at some point be considered as a contract?
Yes, Justice.
So the contract that I'm talking about is in that context. My difficulty was divorcing it from contract and having it as a source of rights and duties, which is of a special kind, not subject to contract. So that was the difficulty that I had. I have no difficulty in saying, well, it's not the ordinary transactional contract. This is an issue that is linked inextricably to the status of the two people. That I understand. It was not to really trivialize the relationship between the parties, to say it is contractual in nature. I was trying to show that for it to come into existence and for it to apply, you have to look at the law of contract for enforcement. If there's no undertaking, reciprocal undertaking to support each other, you can't enforce it. Even if, by nature, it's a lifetime partnership. That is why the other parties have said to us, yes, limit the parameters of today's case are that where in a lifetime partnership, where there has been reciprocal undertakings of maintenance and so on.
Justice Drafter, I see where you're going, but I view it slightly differently with respect.
Yes.
There are two questions. The first question that one must answer at a principal level is there is there a duty of support that arises in the context of this kind of a relationship? We accept as a matter of law that reciprocal duties of support arise as a matter of law in marriages, however one conceptualizes them, civil unions, religious marriages, or other civil marriages. The conceptual question that the court must answer in the first place is, are we prepared as a society to recognize that a relationship, a permanent life partnership that looks like a marriage, that acts like a marriage, that performs the same function in the parties' lives as a marriage? And the only difference between this relationship and a marriage is that it's not called a marriage. It's not a religious marriage. It's not something else, but it shares every other quality with a marriage. And are we as a society prepared to protect women in those relationships? And then if we say yes, then the question of whether or not there was a reciprocal duty of support and what the extent of that duty of support may have been becomes a question of evidence that will then be dealt with by the executors of the estate, because you have to prove a need. It's not just anyone who can come, any spouse. Well, any spouse can ask. Not any spouse would be entitled to maintenance under the Maintenance of Surviving Spouses Act. It's only a spouse or a partner who can prove a need. So the question of need, I think, goes to your question of what that duty entailed in reality. What did they actually do? But the more fundamental question is whether or not as a society we are prepared to say that there's a group of vulnerable women, a group of women who suffer relationship-induced destitution that we are not prepared to protect unless those women can somehow prove that their relationships have this additional factor of being a contract. And that's where, with respect, Justice Drafter, I will have to disagree with you.
As I understand you now, does it mean that this duty to support arises in every lifetime partnership?
In every
regardless
lifetime,
of whether there have been a reciprocal undertaking to maintain and support each other.
in every permanent life partnership which is akin to marriage. And that's the key question. Is it akin to a marriage?
Okay.
Thank you, Justice.
So marriage seems to be playing a dominant role, even though the parties would not have entered into a marriage.
Justice Drafter, the question is about how marriages come into being. And the court in Foltz spoke about choice. Now, the choice to marry is almost invariably not the choice of the woman. That's how our society is structured. Women don't choose whether or not the relationship becomes a marriage or doesn't become a marriage. That is a choice that our society, because of its structure, has left in the hands of the man. So the question then becomes, in circumstances where the man chooses not to get married for whatever reason, it may be a societal choice, it may be a financial choice, it may be a variety of other reasons, but the man chooses not to take this relationship, which looks like a marriage and is a marriage, but chooses not to turn it into a marriage for whatever reason. The question then becomes that what do we then do? That is not the choice of the woman. That man then chooses, in addition, not to make provision in a will for the spouse, or for whatever reason doesn't make a will for this spouse. Now, if this woman happens to be lucky enough to be in the minority, and we know that the minority of women in this country are married, if she's one of those lucky women who happens to be in a marriage, well, she gets protection. But if she's in the majority and she's one of those women who is unlucky for whatever reason, whose partner hasn't chosen to turn this into a marriage, she doesn't get protected. And that's the question.
Well, speaking for myself, I don't think really it should be pegged on the issue of choice. I thought we moved beyond that, where there would have been an undertaking to support each other. That undertaking should be enforced. That I thought was where we are with the development in Pashao as well. But I think your argument goes further than that. Your argument says, forget about an undertaking to support each other. As soon as the lifetime partnership looks like a marriage, then there should be a duty of support, which takes me back to the question that I asked to your colleagues earlier, whether we are saying then that the law should be that as soon as you are in a lifetime partnership, all the rights and duties under a marriage become available to you. And I think the answer was, no, we're not there. We're only dealing with this one issue of support.
Just to address the issue of support in a marriage, you don't have to, you can have a marriage where, as a fact, the husband doesn't support his wife. We know that that happens every single day in this country. But when that man dies, the wife is not required, in order to prove a duty or a claim under the Maintenance of Surviving Spouses Act, that he actually paid support. Because if that were the case, unfortunately, very few women in this country who are married would ever get any support or any maintenance from the estate. And we know that because, unfortunately, we have a very large group of derelict men in this country who marry and don't look after their partners. The reason that we have this kind of legislation is to protect women who find themselves in a destitute position. And that destitution should, and the relief for that destitution cannot be pinned, with the greatest of respect, on the question of whether or not the man as a fact maintained her during his life. The question is the same as in a marriage. Was he obliged to protect? And if you answer no, that he was not obliged to provide that maintenance, well, then you will not find for the applicants in this matter. But if you find that as a matter of law, there's an obligation to provide for his partner, then you will find for the applicants, because that's what the Maintenance of Surviving Spouses Act is all about.
Well,
before you proceed, let me just inform you. The technician and people in my office detected that my screen seemed to be frozen. That's what they told me. They realized that there was something wrong with my connection, so they took it upon themselves to take out the picture. So I thought I should inform you so you're not surprised. You may proceed, my brother.
Thank you, Chief Justice. Ms. Adhikari, lastly, just help me then. If we proceed on the basis that the animal that we have is akin to marriage, and therefore, from that springs rights and duties, are we saying all rights and duties arising from marriage would be available to a lifetime partnership just because it looks like marriage?
Not necessarily, Justice Jafta. We're dealing here with a very specific case based on need. We're dealing here with a very specific case based on a class of vulnerable women who require protection. But there may be a variety of rights and obligations that arise in a marriage which may not implicate the constitutional duty to protect people. It may not amount to a violation to not grant certain rights and obligations to persons in life partnership. But in this particular case, because of the nature of what we're dealing with, because of the nature of the relationship-based destitution, it is hit by the constitutional prohibition on discrimination.
Okay, thank you.
Thank you, Justice Jafta.
Ms. Adhikari,
Adhikari.
would we not,
Sorry, continue, Liana.
thank you, my sister. Would we not be burdening those people who are not vulnerable, who may not be vulnerable, and who have deliberately chosen to be in a life partnership so as not to have the rights and obligations of a marriage flow on their relationship? How do those people who do not want to take on the rights and responsibilities of marriage protect themselves if this court was to extend the ambit to people in a life partnership?
Justice Turon, people who have the resources to arrange their affairs can do so. And we're not here, those people don't need protection. They can arrange their lives in whatever way they choose to arrange their lives. And those people would not fall under this sort of protection because the nature of this protection is twofold. There must be an obligation as between the parties to support, but there must also be a proven need where the partner seeking support post-death cannot meet from his or her own resources. And that's the question. So we're here protecting vulnerable people. And if there happen to be people who are not vulnerable, who also happen to fall into this category, well, so be it. But one can't deny protection to vulnerable people because there may be others who are not vulnerable who may also be caught in the net.
You know what, my sister, before my sister Chikri comes in, and I'm sorry, my sister may not have finished with you, but it's a follow-up. In a marriage arrangement, you'll have those who enter into a marriage out of community of property, but some of them still seek to have a similar benefit as would have been the case in a marriage in community of property. But the advantage there is, because it's a formalized arrangement, there is some documentation to look at for the purpose of satisfying yourself whether the marriage was in or out of community of property. So how then do you deal with it here? Because even some vulnerable people do enter into a marriage out of community of property. But at least, as I said, there is some record to look at for the purpose of telling the difference between those who have entered into a marriage in and out of community of property. What about here? And that's a follow-up to my sister's question. That's why I interrupted, not knowing whether she's done with you or not.
I'm covered. Thank you, CJ.
Thank you, Chief Justice. Chief Justice, if I understand you correctly, your question goes more to the issue of proof. And I go back, at the risk of repeating myself, to the question that is fundamental to this claim, is the question of need. You need to prove that to the executor, the satisfaction of the executor, that you have a maintenance need from the estate. If you can't prove a need, you cannot claim maintenance. So you can claim maintenance under the Maintenance of Surviving Spouses Act, whether you have an antenuptial contract, whether you don't have an antenuptial contract, whether you're married in community of property, whether you're married in, for example, a good example would be Muslim marriages. Muslim marriages are not recognized in the law. Muslim marriages largely are not documented. There's no proof of marriage more often than not. There's no certificate. There was for a long time this fiction in our law that what these marriages were they were not actually marriages. They were some form of agreement, and that's why we protected. Luckily, we've moved beyond that. So the same thing that an executor in dealing with the death of a Muslim spouse, where the only marriage is a Muslim marriage, has to deal with in terms of proof, are the same things that the executor in dealing with permanent life partnerships would have to deal with. They would have to look at the factors that executors look at to determine whether or not there was a need. And that I think answers your question, Chief Justice.
Ms. Adhikari, my concern has recently arisen from your debate with my colleague, Jafta. Because initially I thought that you were basing your argument on Pakshaw. Earlier, Mr. Stelzner had said that life partnership must be distinguished from cohabitation. And I had no problem with that. And I was with him there because he was saying that a life partnership has a certain significance or certain importance. And I thought that one of the issues that one must look at when one is trying to distinguish between a loose cohabitation, if I can call it that, and a life partnership was the whole issue around the tacit agreement of the parties supporting each other. And this is why I thought that you were pinning your argument on Pakshaw. But now, if you're saying that any kind of relationship should be given that status, then I'm worried, because it means that as soon as people stay together, then that duty exists, and it really worries me, because I'm worried now about where do we draw the line, because if we are not supposed to find an express or a tacit agreement between the parties to support each other, then where do we draw the line?
Thank you, Justice Chiki. I understand exactly the problem that one faces, and the proposition is not that any partnership, any relationship would give rise to this kind of a duty of support. It is a very specific type of cohabiting relationship. It's a relationship which is akin to marriage. So it must share the characteristics of a marriage. And that is why I think when I was answering Justice Jafta, I made reference to the factors that the courts look at to determine whether or not there is a permanent life partnership. Firstly, it's the permanency of the partnership. It's the nature of the relationship. Is it marriage-like in its character? How long were the parties living together? Did they share a household? Do they have children? Did they raise each other's children? Was there financial interdependence? What do their wills have to say? And what did the community regard them as? Are they just boyfriend and girlfriend, or does the community see them as a committed life partnership? And if you ask the lady next door, she will say, no, that one is so-and-so's wife. Those are the kinds of things that the courts look at. And it's a very specific type of relationship, and it's a relationship akin to marriage. It's not just you start dating someone and 2 weeks later you move in with them and boom, you suddenly have all of the rights to maintenance as a surviving spouse. You must, as a fact, be a spouse in every way other than with the official imprimatur of either a religious marriage or a civil marriage. And that may, I appreciate, give rise to difficulties of proof and those sorts of things. But as I've said, those difficulties of proof arise in other marriages as well, and in particular in Muslim marriages. And we know that that happens. The matter which ended up in the Supreme Court of Appeal, which was the big Muslim marriages case that was decided a little while ago, one of the clients in that matter, and the client whose case gave rise to the interim relief in that order, her name was Mrs. Farrow, and she happened to have been my client when I was still an attorney many, many years ago. And what happened in her case was particularly egregious because she was a second wife. The first wife had passed. She was married to this man in a Muslim marriage. He then passed away. She had little children and she lived with him, and there was only a house. And then the daughter from the first marriage went to the Muslim Judicial Council and said, this woman wasn't actually married. The daughter managed to get a certificate from the Muslim Judicial Council, which the daughter then took to the master, and the master then effectively kicked Mrs. Farrow off as the executor of the estate and replaced her with someone else. Mrs. Farrow then went back to the master to try and argue her case. The master said, no, you've got to go back to the Muslim Judicial Council. She then did that. She got another certificate saying she was married. She took it back to the master. And so it went on. And eventually what happened was Mrs. Farrow ended up living on the street with her 2 children, living under bridges. And eventually she came to the Women's Legal Center and they tried to assist her. Now, those difficult questions of proof, how do you prove there was a Muslim marriage? How do you prove you were a spouse? How do you prove that you're entitled to maintenance from the estate? Those same types of questions arise in Muslim marriages, which we already protect under the Maintenance of Surviving Spouses Act. So it's the same difficulties that one would face, but the fundamental question is this a relationship which is akin to a marriage, not just a casual relationship? Now, I hope that answers your question, Justice Cheeky.
Well, it does. It's just that my difficulty arose as you were debating with Justice Jafta. I need to reflect on that. But my question, just the last question is: are you at least prepared to accept that in Pakshawo, the court said that there was a tacit agreement that created a binding legal obligation between the parties?
Well, the court found that there was a tacit agreement in Peshawar on the facts, but the court went further. The court said that in order for there to be a dependence action, there needs to be more than an agreement between the parties. And that's what Peshawar paragraph 23 says. The court in Peshawar says that there must be more than just an agreement. And in fact, the fact that there was an agreement is irrelevant, I think was the court's word. There must be an enforceable duty of support which arises from the nature of the relationship. And that was what the court in Peshawar found, that the nature of the relationship gave rise to the duty of support, quite independent of the tacit agreement. The court said the tacit agreement may go to proof of whether there was, in fact, this relationship. But the key question is, did the duty of support arise as a consequence of the nature of the relationship? That is what Peshawar says. That's my understanding, Justice Vicky.
Thank you.
Ms. Adhikari, if I may ask you a question. I have some difficulties with the breadth of the expression akin to marriage. So I would like to approach it from the constituent elements that we're concerned with in the case. What I understand you to be saying is that, yes, if there's an agreement, tacit or otherwise, to support, well and good, then the protection must exist, and it's a matter of proof. There may be situations where de facto there isn't support, but there should be. When you're talking about the recalcitrant breadwinners and that situation, then the decision of the court should actually go to protect that category of people where there isn't an agreement, but there should be, and there should be a duty to support. And in addition to that, what you're also saying is that notwithstanding agreements and the duty to support, there must actually be a need for support. Those do I understand that those to be the three key ingredients, and why you're saying this court should make a declaration to protect that is the difficulties one experiences with proof, and that people who don't need the support already have the protection. Have I got your submissions correct then?
That's absolutely correct, Justice Pillay.
Thank you.
Justices, if those are my submissions, unless there are any further questions.
Thank you, Ms. Adhikari.
Thank you, Chief Justice.
Ms. Pillay.
Thank you, Chief Justice. Justices, on behalf of the Minister of Justice, you would have seen from the papers that he's abiding these proceedings. Justices, you would also have noted that the Minister has not filed any affidavit in this matter. He's filed a set of submissions which have found their way into the record. They appear at volume 6 at page 580. I alert the court to that only for reference purposes. I won't be referring to them for the purposes of argument. Justices, I've listened to the debate, and I think it reduces to 4 issues that I'd like to address the court on. And I do so with regard to what this court had to say about the role of a national minister in the Van der Merwe judgment, which is referred to in my heads of argument, when there is an issue of unconstitutionality of legislation that presents. And having listened to the debate, the 4 issues I intend dealing with in turn is firstly the issue of separation of powers, which Justice Theron, I think, raised at the outset. The second is to make some submissions in relation to the Maintenance of Surviving Spouses Act. The third is to deal with the relief sought in relation to the Interstate Succession Act and the processes that are presently underway. And the fourth is to make a couple of very brief submissions in relation to the question of remedy. So, Justices, if I could perhaps start with the first of those, and that is the question of separation of powers. The starting point is, of course, section 172(1)(a) of the Constitution. And the minister must not be heard to be suggesting that even where there's an unconstitutionality of legislation that's been established, separation of powers precludes this court from ruling on it. Quite the contrary, the minister takes the view that it is incumbent and it is peremptory for this court to issue a declaration in terms of section 172(1)(a). Of course, the question of what other relief the court would find appropriate with regard to its just and equity discretionary powers under 172(1)(b) would be a question of where the question of separation of powers arises. And so if I could make very clear that in the heads of argument that were filed on behalf of the minister, the reference to the law reform process that was made was never said nor suggested impliedly or otherwise to be an argument or to support an argument that says that it therefore provides a blanket immunity against this court making any such argument, any such order. So Justices, if I could then move to the second of the four issues, and that is the question of the Maintenance of Surviving Spouses Act and whether or not, and the role or the arguments that have been presented in relation to it. Justices, perhaps the first point on that is I heard from my learned friend, Mr. Stelzner, repeatedly in the course of his address, that because the minister had not done that which the court had required it to have done 15 years ago, it was appropriate for the relief sought in this regard to be granted. Justices, having appeared in the Robinson case some 15 years ago and having read the judgment in preparation for this matter, there are a couple of things I'd like to make clear on that. And the first is to take the court to paragraph 29 of the Robinson judgment. And the court will see that the Minister of Justice, my client then and my client now, and the master had issued a notice of intention to abide the decision of the High Court, yet it refers to them having submitted heads of argument and made oral argument in the, before this court. And then the court refers to the fact that they argued for judicial restraint in light of the law reform process. That appears at paragraph 29. However, I must emphasize that despite that, the minister's argument around judicial restraint at that point was never the reason for this court's judgment in the Robinson matter. This court's judgment was premised on the fact that there was no unconstitutionality and therefore the relief as sought did not fall to be granted. So in light of that, Justices, the point I'd want to emphasize on that is far from the state not having acted in accordance with what was foreshadowed in a judgment, there was no such suggestion. Justices, if I could take you to a second aspect of that judgment, and that is to refer the court to the majority judgment on the issue of vulnerability and economic dependence. It appears, Justices, at paragraph 63 and following of the judgment. And the majority judgment specifically referred in terms to the structural dependence of women in marriage and relationships of heterosexual unmarried couples. And it went on to talk about the power relations in these relationships. But importantly, is what I'd like to draw the court's attention to is what the court concluded at paragraph 66 of that judgment, which is where the court said in the case of very poor and the illiterate, the effects of vulnerability are more pronounced. We don't take issue with that and continue to accept that. The court then went on to say, the vulnerability of this group of women is, in my view, part of a broader societal reality that, and here's the important part, that must be corrected through the empowerment of women and social policies by the legislature. It is a widespread problem that needs more than just implementation of what, in their case, would be no more than palliative measures. It needs more than the extension of benefits under Section 2.1 to survivors who are predeceased. Unfortunately, the reality is that maintenance claims in poverty situations are unlikely to alleviate vulnerability in any meaningful way. And so to that, I draw the conclusion once again that not just the order made by this court, but indeed its reasoning didn't suggest in any way or form that the state bore any duty or a requirement, as my learned friend Mr. Stelzner put it, to deal with this issue. The third point, Justices, under this issue of the Maintenance of Surviving Spouses Act is this. This is not a case, and certainly as I read the founding affidavit in this matter, and having read the founding affidavit, the minister took a view as to his response to this litigation. The founding affidavit is a claim by an individual, the applicant in this court. The founding affidavit is premised on her personal circumstances and what the appropriate remedy is. It is not premised, Justices, on any suggestion that the state has failed to meet any of its obligations in relation to this matter, or in relation to this category of persons. And so in light of that, we say that, and the submission's been made in the heads of argument that we filed, in light of that, we say that there was no obligation, or indeed not even a suggestion in the Robinson judgment that the state ought to have done differently and ought to have amended legislation to respond to this. Justices, the second point is, what then is the import of the Robinson judgment for the purposes of this case? And certainly as I have it, this court will be governed by the theory of objective constitutional invalidity. Not fact-dependent, objective invalidity. That's been determined by this court. And certainly on my understanding of it, the only basis on which this court would be able to depart from that would be if it were to come to the conclusion that that judgment is clearly wrong. I make no submissions on that in line with the minister's position in this litigation, Justices. The third issue goes to the issue of the factual differences between the Falk's judgment and the present matter. And
Ms. Pillay, the 10 minutes has expired.
Thank you,
You may
Chief
proceed, but the 10 minutes has expired.
Thank you, Chief Justice. And Justices, I say that the factual difference is of absolutely no import to this litigation because of the theory of objective invalidity. But in any event, there's stark differences between the facts in the Robinson matter versus the facts in this matter. One of them being that was a relationship of 16 years during which the parties had lived together. The second of which being that Mrs. Robinson was on the deceased's medical aid, had traveled with him and received a monthly stipend in order to buy groceries. The next is that there was a will there where certain conscious decisions had been made. And another important factor is that there was an issue of the parties having consciously decided not to marry in that matter. So the primary submission I make in relation to the facts is that it matters not based on the jurisprudence of this court. The secondary submission I make is that in any event, the facts are vastly...
Ms. Pillay.
Thank you, Justice Madlanga.
It's not quite, maybe I'm mixing the two cases now, this one and the earlier one. Or in this one, the applicant says, if he had indicated that he wanted to marry me, I would definitely have married him. I almost transposed that to the Folks v. Robinson case. I'm not sure of that detail in that one. I'm sorry.
Not at all. Thank you, Justice Madlanga. And so that then brings me, and so I make those points in relation to the Maintenance of Surviving Spouses Act, Justices, to emphasize the point that the state proceeded on the basis that the highest court in the land had ruled on it. It bore no duty pursuant to this court's order in relation to this. There was a process that was underway, and I'm going to come to that in a short while. But and so there's no question of defiance or disrespect for the orders of this court or the judgments of this court. There's a very specific context in which it arose. Justices, should you get to the question of determining the constitutionality of the Maintenance of Surviving Spouses Act, one question that would loom large is what the import of the settlement agreement is that the parties have entered into. And the court in this regard would consider carefully what appears at volume 6, page 597, and more particularly, if I could just refer the court to the order that was made at paragraph 5 at page 599. And again, Justices, in accordance with my instructions and the position taken by the Minister, I make no submissions in relation to mootness or otherwise. I simply draw the court's attention to that. So, Justices, those are the submissions in relation to the Maintenance of Surviving Spouses Act. If I could then turn to the question of the constitutionality or unconstitutionality of the Interstate Succession Act. Justices, on that one, as I've indicated, the Minister's put up no affidavit that purports to, or that gives or purports to give any justification for the difference.
Excuse me, Ms. Pillay.
Yes.
Just going back to the import of the settlement agreement.
Yes,
Paragraph 4 of that agreement at page 790, it says that the applicant persists in seeking the declaratory relief set out in a notice of motion.
Yes.
Which one?
Yes. Justice Matlantla, I'm sorry, I'm interrupting. Sorry, I can't hear you, Justice.
I'm saying you may proceed with your response.
Thank you. Thank you very much. And so, and the purpose of drawing the court's attention to this is I make no quibble with the fact that the applicant persists with those aspects of the relief, but it's in the context of Mr. Stelzner's argument this morning that it is moot, and the question is whether it requires determination in the interests of justice. And when determining the interests of justice, Justice Matlantla, the court will have regard to this order in its entirety, including whether a reservation in paragraph 4 in circumstances where it would have no tangible effect, and paragraph 5 states in terms between the applicant and the second respondent on it goes.
Ms. Pillay, maybe if you don't mind, if you could just repeat what you said, because for some, we couldn't hear the entire response.
Yes. Thank you, Justice Matlantla. The submission was simply this. I understood Mr. Stelzner to concede in argument this morning that the maintenance of surviving spouses and the challenge in relation to that act was moot as things stood. But that notwithstanding, he submitted that it was in the interests of justice to nevertheless determine the issue. And at the level of legal principle, I take no issue with that. This court has said in numerous judgments that it reserves the discretion to do so. My submission was only, Justice Matlantla, is that when the court exercises its discretion, it will have regard to what the import of this court order is in its entirety. And that would include the reservation of the matters identified in paragraph 4, and it would also include the unequivocal statement in paragraph 5 that any order will not negate the settlement that has been reached. So it wasn't intended to go any beyond that, Justice. So, does that answer your question, Justice Matlantla? Thank you. So if I could, I was then on the third of the three issues, and that was the question of the Interstate Succession Act and the import of it. And I started the submission by saying that the state had not filed any affidavit in which it sought to justify its position in terms of limitations inquiry insofar as this act goes. This court has repeatedly said that in instances where the state seeks to justify a limitation, it's incumbent on the state to put up the evidence in support of that. That's the first point I make. Justices, the second point I make is that that notwithstanding, this court will ultimately determine A, whether or not there's been a constitutional breach that has been established, and therefore whether the declarator is warranted, which is peremptory under section 172(1)(a), and B, consequent on that declaratory relief, whether justice and equity would demand any other relief attendant on that. And when the court exercises its discretion, the minister has referred to the law reform process that's underway. And justices, I must perhaps just be a little bit careful on this in terms of getting the chronology right. My learned friend, Mr. Stelzner, took the court through to the Domestic Partnerships Report, which appeared from the Law Reform Commission in 2006. It appears in his schedule attached to his heads of argument. The court will also be aware that we had the Civil Unions Act, which came about on the 30th of November 2006. And the court will be aware that we had the Domestic Partnerships Bill of 2008, which didn't progress further than that. Against that, justices, we have referred to the present law reform process that's underway. And if I could draw your attention to what's stated at paragraph 12 and following of my heads of argument. And the court will see from there that the minister draws the court's attention to the law reform process, that there was a first issue paper that was published in April 2019, and we presently have a discussion paper which is open for public comment. Justice Majid, you posed the question to my learned friend, Ms. Christians, well, what is the position in the bill as regards the question of the current legislation being extended? And if I could draw, the court will see in our heads of argument, we've provided the website reference where this report is available. It's in excess of 300 pages. But the court will see that there are two different bills that have been proposed, two different options. But if I can draw your attention to the section 3 in both the options presented in the bill. Because importantly, what section 3 says is that it says whenever legislation or common law attaches consequences to protected relationships, the relationships as defined in this act are deemed to be referred to, regardless of whether they've been registered in terms of this act, in terms of the Marriage Act, or in terms of the Civil Unions Act, or the Recognition of Customary Marriages Act. And so, Justice Majid, I would submit that, of course, this is not, it's going to go, it's presently in the process of public comment, etc., but it's certainly reflective of the Law Reform Commission's reasoning or inclination at this stage of the process.
Ms.
Can I
Pillay?
just check that? Can I just check then, Ms. Pillay, is the single marriage statute, which is envisaged in the Law Reform Commission's latest discussion paper, is that meant to substitute the Domestic Partnerships Bill that was mooted in 2008?
That is so, Justice Majid. So things have moved on since then, and having been involved in, of course, the Muslim marriages challenge, having been involved in the case law having developed in relation to same-sex partnerships, etc., the intention is to go with a single piece of legislation that would regulate, and I think it uses the term rationalize and ensure consistency across the board, Justice Majid.
What concerns me, though, is that I take the point that you make that this didn't arise because of Fox versus Robinson. The point is it arose because of a Law Reform Commission discussion paper that saw the need for reform.
Yes.
And then 15 to almost 20 years later, nothing has happened. And instead, a completely new process has started of legislation while persons like the applicant here, and we are told by the amici, many others, are left destitute while they wait for the legislation train to finally reach the station.
Yes.
Why should this court countenance that if unconstitutionality is clear?
Yes, Justice Majid, I mustn't be heard to be perhaps I must be cautious about not being misunderstood, and let me say it this way. The state's starting point is if there is an unconstitutionality, law reform process underway or not, it is incumbent on this court to make a declaration of unconstitutionality. As regards the second issue, and if I understand it correctly, Justice Majid, it's well, the Law Reform Commission determined several years ago that there was a need for this kind of legislation, and it has not yet seen this light of day. Justice Majid, I say two things in response to that. The first is that was not the basis for the applicant's challenge in this. Had the challenge been notwithstanding the state having borne an obligation to do so since 2008 or whatever it is, it has manifestly failed to vindicate a constitutional obligation. In those circumstances, Justice Majid, it would be a question of the legislator, or certainly my client, coming in and answering factual allegations to that extent and explaining the position. That wasn't the case it was brought to court to meet. The second, Justice Majid, is this. There's a law reform process that's underway, but I would submit with respect that the question of whether legislation in a particular area falls to be adopted or not is a question of legislative choice in relation to it. And absent a finding of unconstitutionality, which we say that the Ethel Robinson case didn't result in, the state bears no obligation. And despite there being no obligation, Justice Majid, I say that there's been a process that's underway in any event.
Okay, thank you. I just want to then ask you on something else. As I understand your written submissions in this court, you are submitting that both the challenge of unconstitutional invalidity in respect of the Interstate Succession Act, but also the Maintenance of Surviving Spouses Act, should fail because of Vox versus Robinson. You say that that case correctly held that the differentiation is justified, that the differentiation does not is not unfair discrimination, and unless we find that that case was clearly wrongly decided, we are bound by that decision, and therefore the challenge here should fail. That is, in essence, your case here. Your submissions.
Perhaps just subject to one caveat, Justice Majid, and that is what I say at the preamble to what's stated at paragraph 8 of our heads of argument, which is where we state, consistent with this finding of the High Court, the minister had in fact approached the issue of permanent opposite-sex life partnerships on the basis of this court's judgment in Fox, and more particularly the following findings.
Yeah, thank you.
Thank you.
Ms. Pillay?
Yes.
Ms. Pillay? In response to or taking up your submissions to my brother Majid's earlier point, so would it be fair to say that a declaration from the court would assist the legislative reform process or not?
It's difficult for me to answer that, Justice Pillay, for two reasons. The first of which is, of course, there is a process that's underway. The state's placed no evidence before court as to whether or not it needs a nudge from the highest court in the land in order for that process to see the light of day. And so I would submit that the basis on which this court ought to find is an objective inquiry as to whether there is an unconstitutionality. And if there is an unconstitutionality, then it must follow that the declaration falls to be granted on that. absent an unconstitutionality, Justice Pillay, my submission would be that there'd be no basis for this court to issue a nudge to government to get the show on the road on it. So, yeah.
Thank you. You've answered me.
Thank you. Justices, then can I then go on to perhaps just the last of the 4 points I had intended addressing, and that is the question of remedy. And there are a couple of things that are clear, I would submit, in relation to remedy. The first is the declaration of invalidity, if there is such a finding. And the second is the the legislative latitude that government has in terms of remedying the unconstitutionality. There are, however, 2 other points which I make no submissions on, but the court will consider. The first of those is the question of interim relief and whether it would be competent or not on the facts. And the second would be the ambit of the retrospective effect of this order. And as to the latter issue, the ambit of the retrospective effect, if I could draw the court's attention to page 11, paragraph 18 of our heads of argument, where we say effectively this court should follow the Gori type order, which is to accept that it would have no impact on transfers that have already been undertaken, save to the extent that there's an establishment that transfers have been undertaken while legislation was pending on this. So save for that slight tweak, those are my submissions. Justices, the last issue on the question of relief is the question of costs. The High Court made a costs order against the state in the matter, notwithstanding the fact that the state didn't oppose the application. The state, however, hasn't appealed against that costs order. And there is, as the court's well appraised, there are a line of cases where the courts held, well, if it's legislative invalidity, it is the state that ought to be held liable for it. I make no submissions on that either, simply to draw the court's attention to that point. Justices, those are my submissions, unless the court's got any further questions for me. Thank you. Thank you, Chief Justice. Justices.
Thank you, Ms. Pillay. Thank you. Mr. Stelzner.
Thank you, Chief Justice, Justices. I will be hopefully shorter than the allocated time, given that I think I extended my allocated time when addressing the court originally. The fact of the matter is that the amici, including my learned friend for the Minister of Justice and Constitutional Development, are actually addressing issues which go further than the applicant's case and the specific relief that the applicant sought. We have no objection to that, given that the applicant raised these constitutional issues and that this case calls for those constitutional issues to be addressed. But the starting point we respectfully submit is that the applicant has, with all due respect, established an entitlement to the relief that she got from the High Court as far as the Interstate Succession Act is concerned. And the first port of call is then the confirmation of that order and the costs order of the High Court, and then the costs of this application. So we respectfully submit that as far as the applicant's own case is concerned, she has made out a good case for that relief. And that then also addresses a number of issues that have been raised by the court in questioning my learned friends, such as, does one go further than those requirements that the applicant has said needs to be met in order for the applicant to get the relief that she is seeking? And we say respectfully, both as far as the applicant is concerned and also as far as the general principles are concerned, one should not go further, because if this court does go further, well, only then, and only then, the court may be entering into a realm of separate powers, which then starts legislating for cases other than the one before the court. But the principles that this case establish, we say, are indeed of general application. And I'm not sure whether my learned friend for the Commission for Gender Equality is disagreeing with us when we say an essential requirement is that there be a reciprocal duty of support between the parties in order for there to be a life partnership. We understand that to be a fundamental requirement. Pashao sets the agreement as a requirement in addition to the Boni Mores. The Duplessis judgment of this honorable court, and then also the minority judgment in Folks versus Robinson, they also specifically require a reciprocal duty of support between parties before the court will recognize a life partnership, and then the further consequences of, and in this specific case, one of those partners claiming support against the deceased estate under the Administration of Estates Act, and together with that, the Maintenance of Surviving Spouse Act, or the Interstate Succession Act, or both. So Pashao, we respectfully submit, sets the first requirement, i.e. that there must be a contract and a duty of support based on that contract. And then it goes further, as my learned friend for the Commission pointed out. It also then decides whether the consequences of that contract should be recognized as giving right to a claim against a wrongdoer, a third party who is not a party to that contract, who caused the party to the contract to lose the support that she had during the lifetime of the breadwinner. And it's in that context then that the court looks at the Boni Mores in Pashao to develop the common law to say that although in the past the third party or the RVAF would not have been saddled with that liability under a dependence claim because of the contract, the Boni Mores, the existence of the life partnership, and that was argued the intention to get married, our law has developed to the stage where public policy requires that kind of claim to be recognized. And that is our case in this matter as well. Although we now rely on the Constitution, and the Constitution does inform and reflect the Boni Mores of our society in order to motivate the equal protection on which the applicant relies and the equal benefits on which the applicant relies. We respectfully submit that in order to ensure substantive equality, which Section 9 seeks to ensure, the applicant's claim, and then by extension, all claims of women in similar positions would need to be recognized. It's a constitutional argument, and the fact that the legislature has not dealt with this is why this honorable court, with all due respect, is now saddled with the issue, and why this honorable court has to decide the issue. And in that regard, we rely on Pashao and paragraph 30 of that judgment, where there the counsel for the Road Accident Fund said that the court should not develop the common law to include heterosexual life partnerships, rather leave their regulation to the lawmaker. And the SCA said that that is not persuasive. We are not here embarking on an exercise that impinges on the lawmaker's responsibility for law reform in this area. And it does refer to the Domestic Partnership Bill of 2008. But the courts are deciding on incremental changes which are necessary to keep the common law in step with the dynamic and evolving fabric of our society. The courts have always had this duty, and Section 173 of the Constitution now explicitly recognizes it. So far from my learned friend suggesting that because the legislature only now needs to deal with it if this honorable court decides that Folks versus Robinson and the majority decision there is not in keeping with the evolving, let's call it bony mores of our society, and the need for recognizing claims such as the one that the applicant has presented. The fact of the matter is, and my learned friend and the legislature are not being castigated for this, and we accept it wasn't the case that the legislature has been unduly tardy, and we're not seeking a special costs order against the legislature, and we're not asking the court to express any displeasure in this regard. We're simply asking that the constitutional rights of the applicant be recognized, because the legislature has not done, and we repeat our submission, what the legislature was enjoined to do. If it was not in the majority decision of Folks that the legislature was enjoined to deal with this matter, it was when the Law Reform Commission produced its report and made its recommendation. It was when the Law Reform Commission produced the first domestic partnership bill. The Law Reform Commission in fact drafted the legislation, and as that would have dealt with these, and Your Lordship, Justice Majid, did refer to, I think it's section 19 of that bill from 2008, which then focused on registered partnerships. And then if life partnerships were registered, there would be certain benefits for members of those life partnerships. Now, the latest recommendation of the South African Law Reform Commission is to the effect that even an unregistered life partnership, which satisfies the definition of protected relationships, deserves the same benefits, and members of such a partnership and survivors of such a partnership deserve the same benefits that would be available to spouses under the Interstate Succession Act and under the Maintenance of Surviving Spouses Act. And our note, the annex supplementary note, which deals with this, paragraph 8.5 and point 1 and 8.5.2, has the references to the latest report and shows how the legislature, in terms of this report of the Commission, is nudged, to use my learned friend's terminology, in the constitutionally correct direction. And all it does in paragraph 8.5.1 of our note, which then would be an amendment of the Interstate Succession Act, is to introduce a new definition that spouse, for the purposes of this act, must be construed to mean, in relation to any person, a person who is the partner of such person in a relationship in terms of the Protected Relationship Act. And similarly, as far as the Maintenance of Surviving Spouse Act, someone who satisfies the definition of protected relationship has a claim under MOSA. That is where we are now. But until such time as the legislature gives consideration and ultimately, hopefully, effect to that, the inequality which exists can, we respectfully submit and must be addressed by this court to grant this applicant the relief that she is seeking, and on behalf of many others then as a result thereof. There is a recent decision of this Honourable Court a year ago, which I would respectfully just bring to the attention. Well, it's not really necessary. I'm sure the court is well aware of it, but it's a decision which deals with substantive equality and the importance of substantive equality as opposed to formal equality. It's the decision of this court in BEDICA, I assume, BEADICA versus Trustees Oregon Trust, 2020, brackets 5 SA 247, and paragraphs 99 and 100 deals with the importance of substantive equality. And that in turn refers to the Minister of Finance and another versus Van Heerden, which is also the judgment of this court, 2004 6 SA 121, which in paragraph 27 talks about the substantive notion of equality, recognizing all the issues which we have presented to this honorable court for its consideration. I was asked about the Maintenance Act by Justice Pillay, and at the time it escaped my attention that we do in fact deal with whether life partners have a claim under the Maintenance Act for support during the lifetime of both partners. And we, in paragraph 102.3 of the applicant's heads of argument in this matter, we refer then in the footnote there, which is 90, to an article of Smith, Dissolution. It's the law of divorce and dissolution of life partnerships in South Africa. And in that case, at page 456, with reference to footnote 539, the learned author refers to the Maintenance Act, section 2.1, which says the provisions of this act shall apply in respect of the legal duty of any person to maintain any other person, irrespective of the nature of the relationship between those persons giving rise to that duty. So it deals with anyone who's under a legal duty to maintain another, and then it says irrespective of the nature of the relationship between these persons giving rise to that duty. So we respectfully submit, and the learned authors of that view as well, that the Maintenance Act already has cost the protection and the benefits for also life partners wider than simply those who are married to each other or are parties to a religious marriage, which has already been extended. Irrespective of the nature of the relationship, if there's a legal duty to maintain a person, the learned authors there say contractually created reciprocal support obligations between life partners can be regarded as legal duties in view of the Duplessis versus Road Accident Fund case and Peshawar. So the court, this court has, as we have seen, when deserving cases present themselves before the court, where it is clear that there's constitutional inequality, extended the protection and the benefits. And we respectfully submit that this case is one deserving of that. Unless there's anything specific that I failed to address. Yes, thank you, Justice Tron.
In your closing submissions, in your main address, part of the relief that you requested costs in the High Court. The High Court in paragraph 10 of its order granted applicants the cost in that court. So I'm not sure why that request is repeated in this court.
Yes, I think it's just an abundance of maybe greed. No, caution, Justice. We asked for confirmation of the court order, but although the confirmation was essentially in respect of the constitutional issues, the relief that we're seeking is the costs in this court, and the High Court has already granted us the costs. So if it's not necessary for that part of the High Court's order to be confirmed specifically, then we are, with all due respect, quite happy that for the Constitutional Court to simply decide the constitutional issues which are before it, including the confirmation of the High Court's order as far as the constitutional aspect is concerned. And then I don't understand the Minister of Justice to be opposing the costs order that we're seeking. I understand that's on the Biowatch principle, namely that the applicant in this case is, with all due respect, to a large extent doing the Minister of Justice's work for the Minister of Justice and Constitutional Development.
Mr. Stelzner, I also have a question of cost, which I omitted to ask in your main address. If I may do so now, it's a question of 3 counsel. Yes. The norm in complex matters is the cost of 2 counsel. And in this matter, you have confirmation of an order of constitutional invalidity. And secondly, you now concede that the matter, as far as the MSSA is concerned, is moot, but you submit that in the interest of justice, the matter should be decided nonetheless. Why should we, because the minister is going to pay, the minister's got no objection to it, why should the taxpayers be burdened with the cost of 3 counsel as opposed to 2?
Yes, we're in the court's hands. We understand that in matters which are more complex than most, more voluminous than most, maybe more important for many more people than most. In those cases, the court would give 3 or 4 counsel the costs, but the court has the discretion not to do so. We respectfully submit that the wealth of material, the academic articles, the extent of the Law Reform Commission reports, the history of all the amendments to legislation dealing with these issues, the cases incrementally addressing the relevant issues, and the importance of the matter would have warranted 3 counsel for this round of the exercise. I understand the Department of Justice is not appealing the costs order which was granted in the court below, but we are, as in the hands of the court, as one always is with costs. And if the court is of the view that 3 counsel was not warranted, well, then we would respectfully submit the costs of 2 counsel would be warranted, and hopefully I would be one of those counsel, as the court pleases. Those are our submissions. The relief, we've already touched on that, or the remedy, we touched on that at the outset. The applicant is entitled to relief for her specific case, and we are in agreement with the Minister of Justice that the Gorvin versus Corby, or the minority decision in, Gorey versus Corvin, and the minority decision in Folks versus Robinson is the type of remedy which would be appropriate here. Those are our submissions.
Thank you, Mr. Stelzner.
Thank you very much,
Judgment
Chief.
is reserved and the court adjourns.
As the court pleases. Thank you for hearing us.
Today's proceedings have concluded. The host will now terminate the meeting.